Good morning, beautiful people. Good morning. I'm just going to get us queued up for Karen Reed because I think we're going to have to watch Amelie after they air. I think Law and Crime usually records and then uploads. So we may not get Melly live today, which is fine. But we will watch it whenever it uploads. We'll watch it, or if it does it late, I'll watch it and do a recap. So just getting us queued up for them. We're going to finish Tyre Nichols, closing arguments. I don't think it's going to be streamed live. Grand Rising, Robin. Good morning, Kim. Good morning, D Wood. Yeah. So I will be in the comments. I got to get my people out the door.
don't either.
Please be seated. Court is in session.
All right, so I was told counsel wanted to see me. Okay.
Yeah, there's no. All right, so the court, please. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. This court is in session. Please be seated.
Good morning again, council. Good morning, Marie. Good morning, jurors.
Good morning.
Thank you for your patience this morning. We were able to get some work done that will help facilitate things and make everything go a little more smoothly. So we appreciate your patience. I do have to ask you those questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no or shook their heads. Thank you. Can we have Lieutenant Gallagher again, please?
Sir, I'll remind you, you're still under oath. Good morning.
All right, Mr. Jackson, whenever you're ready.
Good morning, Your Honor. Thank you. Mr. Gallagher, good morning.
Good morning.
Thanks for joining us again. I want to ask you a quick question about what we talked about yesterday concerning your search at the scene. If we could go back to that, when you engaged the leaf blower. During the time that you were removing materials in and around the area of the flagpole going out to the, I think you called it the berm, B-E-R-M, the berm, the curb.
Yes, that was at the street. There was a 6-inch Cape Cod berm. Yes.
Okay, and that led straight to the asphalt of the street, correct?
It's basically a curbing. It's
Okay.
where the property line, the grass, the lawn meets the street.
And you were searching the area where you believed Mr. O'Keefe's body to have been found, all the way out toward that curb or berm area, correct?
Yeah, we did not go out to the berm. We did about approximately 6 by 6, 7 by 7, about 50 square feet.
50
area.
square feet. Okay, fair enough. But
Approximately.
you did say at some point, I think on direct examination, you said that you exposed the berm
Yes.
just to give you some orientation as to where the curb was, where the street was.
And if it was possible, he may have tripped and fallen. Yes.
Okay. You did not recover or see a hat, a man's hat,
No, sir.
black
No.
in color, baseball style hat.
No hat. No, sir.
You did not see or recover a man's shoe.
No, sir.
And you said you searched for the area in that 50 square foot area by removing materials, moving the snow, getting down to all the way down to the lawn.
Yes.
Okay. You did not see a single piece of bright red plastic taillight material either, did you?
No, sir. Not in that area.
As a matter of fact, you didn't see 46 pieces of taillight material, either clear or bright red plastic, in any part of the area that you searched.
No, the only thing we discovered was the blood sampling in the glass. That is correct.
Speaking of the glass, that's a good segue. You found that piece of broken drinking glass that you brought in and showed the jurors yesterday, correct?
That's correct.
Did you search the house at all to determine whether or not there was any matching glass in the home?
No, I did not.
You testified yesterday that you looked around when you were in the house. This is the second time you're at the location. So you went back with Sergeant Lank. I want to orient you to that time. That's when you actually entered the home for the first time of Brian Albert. Was that right?
That is correct. Yes, sir.
And you indicated that you did look around the family room, the kitchen, and you didn't see any signs of a struggle or anything like that.
No, sir.
I asked you that exact question about a year ago at another proceeding. Do you recall that colloquy between the two of us?
Yes.
And at that time, I asked you, did you look around the house for any sign of a struggle or a fight? And your answer was no. Do you remember that?
Yes, I think that's out of context. I understood that question was, did I wander the house to look for any sign of a struggle? I believe you asked me if I went to asked me about a bulkhead and things of that nature.
Okay.
As I stood there, I have observations I can see.
Right.
So I think it's just a miscommunication on what type of search.
Fair
or
enough.
What type of observation.
Fair enough. Let's clear that up right now then. Mr. Gallagher, with regard to your the time that you were inside the residence, you did not seek to or ask permission to look around any place other than where you happen to be standing, which is right inside that front door of the family room, sort of adjacent to the kitchen area, correct?
That is correct. Yes, sir.
You didn't walk into any adjacent rooms?
No, sir. No, sir.
Okay. You didn't walk into any, you didn't search the kitchen area?
I did not. No, sir.
You didn't look through the cabinets or anything like that?
Absolutely not. No.
You didn't look at the glassware?
Absolutely not. No.
You didn't go down to the basement? We talked about that previously.
Correct.
And-
No, absolutely not.
Okay. You didn't go out to the garage?
No, sir.
You
No.
didn't look around the garage?
No.
Other than walking in and basically where you just described, standing while Sergeant Lank was engaged with Miss McCabe, you didn't do anything to search the interior of that house for anything.
No, I wasn't there to search at all.
Okay. You also didn't, subsequent to that, you didn't seek or receive a search warrant.
No, I did not.
Okay. You didn't believe that it was necessary, in your mind, it was necessary to seek a search warrant to search the interior of that house.
That's absolutely correct.
You were aware at the time that you did go into the house that Sergeant Lank had earlier reported at least the possibility that John O'Keefe may have gotten into a fight, correct?
I don't recall that. We went over options on how he could have come to where he was, and an altercation certainly was one of them.
Okay, so that's fair enough. So an altercation meaning was when you say altercation, that means a physical fight, correct?
Sure.
So that was a possibility in your mind.
Everything was a possibility at that time.
And at that time, you had the information that you found, or Mr. O'Keefe's body was found on the lawn. of a residence where there was alcohol, drinking, a party of some sort, or a gathering of some sort, just hours early.
That's correct, but the house had nothing to do with the incident.
At least to your mind.
That's correct, based on the evidence, yes, at that time.
And the evidence at that time was simply your communications with some, but not all, the occupants of the house, including Jennifer McCabe, correct?
That is correct, yes, sir.
You didn't separate any of the witnesses that were, or any of the occupants that you saw inside the house, or you came across inside the house, for instance, by taking them to the station, putting them in separate rooms so that they couldn't coordinate testimony, things of that nature?
At that time,
At that time.
so Detective Sergeant Lank was there to speak with Jennifer McCabe only.
Okay. But there were others in the house.
There were others in the house, yes.
I'm just trying to figure out whether or not you took the added step of separating those witnesses, asking those witnesses potentially to join you down at the station, putting them in separate rooms, separating those witnesses. You did not do that.
Not at that time, no.
Okay. At any time, did you?
No, we shortly thereafter, we were removed from the investigation. We removed ourselves from the investigation.
And before you were removed from the investigation, you just left the house after the conversation that Sergeant Lake had with Jennifer McCabe, correct?
Yes, after he took Jennifer McCabe's statement, we left the house, yes.
Is the reason that you didn't seek a search warrant or separate the witnesses or ask any of the potential witnesses to join you down at the station, did that have anything to do with your knowledge the homeowner was a police officer?
Absolutely none. I've actually executed warrants on police officers' houses in the past, including police officers I personally worked with and had to charge some of their children. So that absolutely would not factor into a reason.
And it didn't factor in this case?
Absolutely not.
It did factor into your decision making that Brian Albert was a police officer?
Absolutely not.
He didn't get any special treatment because of that?
Not by me, absolutely not.
Okay, not by you?
Not.
Okay.
I can only speak to my personal knowledge.
You were aware that, and you indicated yesterday, that the reason that Canton PD was removed from the investigation, or at least the interview section of the investigation, was because of a relationship of one of your detectives. You indicated your best detective, Kevin Albert, correct?
That's correct.
Or you gave Mr. Albert or Detective Albert very high praise,
He's a very good detective, yes.
and you were his direct supervisor.
I was at one point, yes.
Okay. You're aware that Kevin Albert was disciplined by the Canton Police Department for an incident occurring in July 2022, correct?
I am, yes.
Do you stand by your testimony knowing that Kevin Albert is your best detective, or was your best detective?
He's an excellent detective, yes.
You indicated that you contacted your deputy chief, Deputy Chief Kelleher, and ultimately secured some solo cups from Deputy Chief Kelleher across the street, correct?
That is correct, yes, sir.
You were aware at the time that Deputy Chief Kelleher's house was adorned with a Ring video camera just over the front door, facing out toward the street and facing across the street, which would be facing 34 Fairview, correct?
That is incorrect. He does not have a Ring camera. I know that his system is an Arlo camera, and I have personal knowledge of that because we've discussed cameras because we bought them approximately the same time.
My mistake. Arlo camera, ARLO.
I believe so, yes.
Okay, that's still, although it's a different brand, it's still a home personal surveillance camera, correct?
Yes, but
And you're aware that those are motion activated cameras designed for security to capture images of things that may be going on outside the home.
that is correct, yes, sir.
May I approach, Your Honor,
Yes.
briefly?
Thank you.
Mr. Gallagher, would you take a look at that photograph that I just handed you?
Yes,
What's it marked for ID?
It is marked for ID, and Mr. Gallagher, if you could read that for me to save me a trip up to the stand.
I believe it's a 5, Exhibit 5.
Could it be an S?
It could be an S, yes.
I think it's S, Your Honor.
I apologize.
Let me, it is S? Okay, thanks. Thank you, Mr. Gallagher. Do you recognize what's depicted in that photograph?
I recognize the camera and the door.
Okay.
Yes.
Is that a shot of Deputy Chief Gallagher's, sorry.
That's okay. I know what you're asking.
Is this a shot of Deputy Chief Kelleher's front porch?
It appears to be.
Okay. Does that front porch face 34 Fairview?
We need a time frame.
I'm sorry, Your Honor?
We need a time frame.
Sure. Did you see that Arlo camera so situated when you went over there on January 29th, 2022?
I knew it was there, yes.
Okay. And is that a fair representation of what the camera looked like and its positioning, basically its positioning in January of 2022?
Yes.
Okay. Did you seek the footage? From the
No, I
camera?
didn't. I know what that camera captures.
Okay. Your Honor, with the court's permission, when we publish, actually, I'd like to mark this as evidence next in order.
Okay.
If I may approach.
Yes.
Is it 53?
May I publish, Your Honor?
Yes.
Mr. Gallagher, do you recognize this as being the photograph that you just saw, Exhibit 53?
That is correct.
Okay. I'm going to draw your attention. And by the way, there's one amendment to this photograph. There's a redaction of the address. You see that?
Yes.
Okay. I'd like to draw your attention to that area right there, which I'm
Yes.
highlighting.
Yes.
What is that?
That is the Arlo camera.
Can you orient the jurors for us, please, to what we're looking at in this photograph?
You're looking at a camera that's angled downward.
And is it the front porch of that residence directly across the street from 34 Fairview?
It is not directly across from 34. It's actually more directly across from 32, so that would be incorrect.
Okay. Is it across the street from 34 generally?
It is, if Lieutenant Kelleher's house is here, 34 is over here across the street.
Okay. Is there a view from that front porch, just generally as you're standing there, if you were to turn 180 degrees and put your back to the door, is there a view of 34 Fairview as well as 32 Fairview?
Oh, sure, absolutely.
Okay. Did you seek and we can take this down.
What we believe is, let me pause on that real quick. State, what's your position, first of all, on the argument that the exclusionary rule applies to a bond?
That it's actually, I believe, addressed under 924.071, additional grounds for appeal by the state and time for taking state of cause. The last sentence, referring specifically to bond issues, talks about that. The defendant in custody whose case is stayed either automatically or by order of the court shall be released on his or her recognizance pending the appeal if he or she is charged with a bailable offense. Mr. Demons is not charged with a bailable offense. So what the court, or what the statute contemplates by that is if the state is some reason taking an appeal, which we did in this case, that his bond condition effectively remains the same, he's not entitled to the ROR. So I interpret that as because the issue is up on appeal, because the issue is essentially non-final, because it is before the fourth DCA now, that the exclusionary rule does not apply until there's an actual ruling from the fourth DCA, because obviously at that point there would definitely be a definite change in posture depending upon what is ultimately suppressed or if anything is reversed by the court.
Well, hold on. You disagree with Mr. Demons?
Yes.
So you want me to consider everything in fact?
At this point, yes.
If I think that he is right, I'll ask you the same thing. Judge Murphy's order said that you two were all of you were supposed to get together and determine what specific evidence his order was going to exclude and what it wasn't going to exclude. So that never happened.
That never happened.
Okay. So you want to take their suggestion and give you all a couple minutes and see if you can figure out what this order may or may not cover?
Yeah, I mean, in 10 minutes, it's not going to happen, Judge. There was a lot of evidence. There was recovered both from all the different houses.
Ms. Liberty?
There was a lot of evidence.
No, ma'am, I didn't ask for the response. I don't understand your continued behavior, speaking out of turn, yelling at someone that's not true. what part of the rules of criminal procedure or the Florida statutes or any case law says that you get to do that just when you feel like it? Did Judge Murphy allow that?
No.
I'm not going to. Do you understand what I'm saying? Do you need any questions or any clear for you on that regard? Everyone is entitled to respect, everyone is entitled to be heard. One voice at a time for the court reporter. I'm not gonna let anyone shout over you or interrupt you or call you a liar while you're sitting at the podium. And I can promise you, I'm not gonna allow you to ever do it again. Do you have any questions about that? Okay. Go ahead, sir.
Judge, there was a lot of evidence that ultimately was suppressed. Not all of it was used in the first trial. Obviously, the team now is considering using stuff that is currently subject to suppression that we may end up using in the next trial, assuming the fourth reverses or whatever may come of it. In anticipation of today's hearing, in light of Mr. Benjamin's response or motion, I have a general idea of what's going to be excluded based upon the date ranges that are provided in the order, but I'm not in a position to give specifics, and it would probably take more than 10 minutes to actually go through it. If we were to itemize everything, that's going to be a rather lengthy endeavor. Probably at least a good day or two if we were to sit down and go through everything. And that's obviously we disagree with the exclusionary rule apply.
No, I understand. This is,
I believe that Judge Murphy's sentence at the end that Your Honor just read is about preparing for the next trial and deciding which evidence that was in the first trial is not suppressed, is not going to be, is pursuant to the motion to suppress. I don't believe it is needed to go over for purposes of Your Honor's consideration because it articulates exactly dates and parameters of the evidence that was suppressed. I don't think it says Exhibit A, Exhibit B in that manner, but it does have the parameters of what was suppressed by date and description. So the other part that he wrote, I don't believe changes his suppression motion. It just, I believe, augments it for later consideration at the trial by exhibit number or exhibit letter, whichever they were on. So I think that's the difference there. And I got to address the state saying that rule says that it's available because he's not entitled to a bond and we can't come back and have a bond hearing. That particular part says he shall be released in those other cases. It doesn't say, and he can't be considered in further bond motions. There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
Right.
I gave you a whole day. I'm happy to listen to anything you want to tell me. But this single sentence, I don't know that I agree with your interpretation. The court has not been moved to consider the suppression of specific evidence. So do you all want to tell me what you want me to not consider, or do you just want me to take a shot at it myself? I didn't have the benefit of sitting through this motion. So I don't have an order that says a motion to suppress is granted regarding the defendant's statement. A motion to suppress is granted regarding the cell phone records from T-Mobile. A motion to suppress is granted regarding any of these things. So I don't know what the specifics are. So I can figure it out. If you're telling me to take a shot, I guess I'll take a shot.
It is attached to the amended supplement, the bus order.
Yeah, I read it.
Yeah.
That's why I'm asking you this.
So if I could.
I mean, there's several that say he granted it in part, denied it in part.
May I clarify, Judge?
Sure.
So if you actually go into the order, a lot of it, he's granted in part, denied in part. He goes and talks about the temporal span of those orders, saying specifically, highlighted what he said, in reference to his iPad account, that they're limited to a span of 24 hours. Common sense dictates predated the deaths could not come in. And anything after the arrest could not come in. You were stuck to that time period. The next one would have been Twitter. Twitter was based on the same analogy that the time period was too large and it had to be based upon date of death to time of arrest. When we go to the next motion to suppress, Google was all the way in, and I was out for temporal, in part out for temporal. The Snapchat was out from the time period predating the deaths and then time period after arrest.
Judge Coleman, something unrelated?
I just need to know when this child will be available for a change of plea. Because when she keeps leaving, they can't call up for a custody.
We were set for 8:30, Judge, his in custody was not brought until like 16, so I tried to go back.
Thank you.
Yes, sir? Go ahead, sir. Sorry about that.
Facebook, same thing, granted in part, denied in part. The temporal limitations was the basis of the denied. So basically saying from October 26th to February 19th, all of Facebook can come in, all of Snapchat, all his text messages can come in. So it was really clear that it was just, everything was out from before the deaths and after the arrest. So that's when you're looking at granted in part, denied in part, is granted as to the probable cause of the warrant, but it's denied as to the span of the warrant. So really what Judge Murphy did was break it down to where he had a time span of what was relevant and what could come in. His basis, quoting to basically the cell phone contains their entire life. There was no reason a lot of these warrants, and even the new warrants that the state has applied for, because they applied for new warrants based on the evidence that was suppressed, they're going back to the creation of the account. Murphy was very clear that you can't go back to the creation of the account. You have to stick within this time period, and that's what it said.
So for example, the cell phone mapping information that was testified to on the day of the homicide, October 26th, that was not suppressed.
If CDRs are all the way in, the cell
Yeah.
data, yes.
You agree with that?
I agree, Judge. If I can give the court a summary, this is my interpretation as to what's been suppressed or what can be considered or not considered if the court is going with exclusionary rule. As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As to the second warrant, the Twitter account that was granted in part, the past events from leading up to the homicide were suppressed, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. As to as to number 3, the iCloud, that was granted in part. I think we noted that there was nothing of import there, so we weren't using anything from that, or we didn't recover anything from that. To the Snapchat, that was granted in part, again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Mariah Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial.
Just you say out, I don't understand, I just want to make sure.
Out. Mariah Hamilton's text.
When you say out.
Out, as in they're not in evidence. They were suppressed.
Oh,
It's subject to suppression. It's subject to suppression.
I want to make sure out that it was suppressed.
As to number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for January, that remains in. So what the state lost there potentially are photographs related to gang-related activity, the defendant's membership in gangs, as well as some comments and communications about the defendant promoting the promotional video, which is also subject to the appeal, because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th, or at least some of them were, I think. The Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity. Number 8, the T-Mobile records, the real-time location information, that was denied. Number 9, the T-Mobile records for historic location information as to the defendant, that was denied. Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 13th. So we obviously kept anything that was backed up to that phone, including the pin drop information, some notes, some text messages in reference to gang activity. But what we also was suppressed were some of the notes and text messages from the past relating to gang activity. Where'd it go? Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And at number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that, but I believe it's more gang-related stuff. So effectively what was suppressed was a lot of the stuff the state would be using for aggravators.
Cell site location information.
Remains in.
From October 26, 2018. None of those.
Correct. And that's my summary. They disagree because I was trying to prepare this for today's hearing. I didn't have the time to go through every piece of evidence.
I think it was the same for what I said, but just to go a step further so the court understands, I agree with what the state had proffered as far as what's suppressed. Going to what specific witnesses testified to what we agree was suppressed. You'd be looking at the majority of the testimony from Nichols would be out. He testified to a lot of the photographs, Mr. Newman's phones that predated, as Mr. Ferguson said, the bookings, the YNW booking, Gmail had a gang Bible sent, some gang talk sent to that Gmail. All of that is out because it predates the murders. That is most of what Danny Fuller testified to. The second witness who would have testified to certain messages, maybe with Mariah Hamilton, Detective Mark Moretti testified to a substantial amount of text messages that would now be suppressed. So I believe we said close to half a day where he just read text messages off of the screen. Most of that would be out.
How about the text messages from October 26th? Were there any?
Those would remain in. As far as his phone is concerned, it was granted in part from the date of the homicide to February 13th remains in.
Okay. So state any evidence, witnesses, or testimony you want to present, or is it just your argument?
No, Judge, it's just argument. We're just relying on the trial transcript that the court has reviewed.
Your Honor, may I
Sure.
dismiss Dr. Holmes? She's not going to testify.
She's not. Okay, so the record is clear on this, but I'll put it in the written order also. I agree with the defense position. I'm not going to consider anything that was introduced as evidence in the prior trial that has been since subject to Judge Murphy's suppression motion. So I will only consider the things that were not, as it's been articulated to me today by the lawyer. So, defense, I'll let you give me the, well, state, let me get you the approach. You're the ones making the proposition. So, your argument as to whether the proof is evident, the presumption is great. And even if I wasn't to find that, your argument as to whether I should or should not exercise my discretion and give Mr. Dennis a bond. Go ahead.
Certainly, Judge, and that's the case law provided to the court. There's actually a presumption of correctness as to Judge Murphy's order that there was proof evident presumption great. So really what the court is considering now is just effectively has that suppressed evidence that the court is now considering change the state's position where proof evident is no longer present. We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains. So the vast majority of the evidence that was introduced at the previous trial remains available to the state. What the state effectively lost, as I summarized, were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, with the shell casings that were recovered, the fact that the defendant's phone was traveling with the two deceased in this case along with them and then separated prior to Mr. Henry going to the hospital, the admission on Twitter that the defendant made where he said, "I did that." All that stuff that relates to the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state can present to the jury in terms of both aggravators and motive.
So before I hear the defense's argument, based on the written pleadings, I suspect they're going to get up and tell me that since the jury didn't find him guilty of these, that's beyond a reasonable doubt, we were able to do that to the jury. So you're now asking me to find a higher standard that is proof evidence presumption grade. So you have any response to that?
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to cut that.
I have no idea what that.
That it was a hung jury, and we don't know what their decision was.
It was, Judge, I have to check the characterization, and we don't know. It was mistried because they couldn't unanimously decide, which is the standard by which somebody is found guilty or innocent. So,
No, I'm not considering those. It was a mistrial. I got it. Anything else?
No.
Okay. Defense, your argument as to why I shouldn't find proof evidence presumption grades, even if I did, your argument or anything you want to tell me about whether I should nevertheless exercise my discretion and set some form of bond or pretrial release, and if I decided to do that, what exactly are you asking me to do? Go ahead.
for the purposes of the proof evidence presumption grade, I have some factors. I know Ms. Liberty has a couple. If I could, Judge, I believe that the rulings by Judge Murphy, that starting with the testimony of Michelle Boutros, which the Judge Murphy ordered the state that when she testifies, they cannot cross-examine her in any further proceedings. The state appealed it on a motion, on a appeal, a writ of some sort, I forgot which one. And that was, and I attached it to my supplement, the fourth denied their seeking relief on that issue. So I believe that Ms. Boutros, who witnessed Mr. Moretti, the lead case agent in this case, suborn perjury, will come in with no cross-examination in the trial. And I believe the evidence of Detective Moretti suborning perjury in this case is another factor Your Honor should consider, because that didn't exist in the other trial. And it has occurred after the fact, and it's been ruled on by Judge Murphy that Ms. Boutros is going to testify unchallenged by the state in the next trial. And I think that's something Your Honor can consider. There's transcripts of her testimony and what she saw and what Moretti did. And I think that's another factor Your Honor should consider. I believe there's something else that came up. You know, Judge, we got on the day of discovery cutoff, was it Friday? April 30th, so it's 6 days ago. A new set of warrants and affidavits authored by Moretti that were done a year and a half ago after Judge Murphy suppressed by this, for the same records that were stayed on appeal. And in those affidavits that he presented to various judges, mostly Judge Bober, nowhere did Moretti ever state that these issues were on appeal, that there was a stay, that they're asking for an expanded amount of records for the same social media and the same phones to a certain extent. And we found out about it a year and a half later, just the other day. We couldn't prepare defenses up until then. And Your Honor keeps reminding us we have this trial date. And all of a sudden, we get all of this other results of a search warrant that was signed by a judge who didn't even know about the appeal or what was going on with it. So all of that is additional, and we're going to do a motion on prosecutorial bad faith, prosecutorial misconduct, police misconduct. We have to add all this stuff to it because it's new stuff that we just learned about less than a couple of days ago. But I think that's something that Your Honor should consider. What are we doing here when the 3.220 says they have an ongoing obligation for discovery? They sought this information a year and a half ago in March of 2024, however that adds up. And they've had it since, and we don't get it until 5 days ago. This is obstruction. This is absolutely unethical. This is absolutely not professional. And this is and the kind of thing that we're facing from this state attorney's office on an everyday basis. Every day. And I believe that the sub-issues there of forum shopping to go to other judges who don't have the institutional memory of this case is about, and Judge Murphy was still there back when they sought these warrants. So did they advise Judge Murphy that we're going to go do an end around? Did they advise the fourth that they're going to do an end around and seek the same and expanded amounts of information from those cell phones when the judge said it was overbroad and he suppressed all of the overbroad nature of those results of the search warrant? So it's under suppression, and they're telling another judge, go in there to try to get the same information, but broadly, so they can try to fix a warrant by not telling anybody they're doing it. So we're going to get to it at some point, but I think on a proof evident presumption grade standard, it's another thing that Your Honor should consider. At the time of the first trial, the predecessor prosecutor, Ms. Bradley, hadn't filed 3 or 4 different Brady notices for evidence that they suppressed and didn't tell us about on the first trial. And that's hearings that took place, and Judge Murphy kicked her out of the courtroom. And that's why these people are here now, because she is a possible witness, because she filed 4 different Brady notices to us. They were all different. So that's something I believe Your Honor can consider, because that happened after the trial, and it affects the credibility of the state's case against Mr. Devins. And that's a factor I would submit respectfully that Your Honor should consider. And I know I don't have them all, and I didn't mean to step on Ms. Liberty's argument, and I know she has some other stuff.
Let me just summarize very briefly. I think the court hit the nail on the head when you said the jury couldn't reach a verdict and the proof evident presumption grade is a higher burden than reasonable doubt. The jury in that case did not know, it was hidden from us, that the lead detective attempted to suborn perjury, although the state knew about it prior to the trial. And that is why the lead prosecutor was removed from that case. Had the jury known that the lead detective was involved in criminal activity, I suggest that any reasonable person would totally discount his testimony completely, coupled with the fact that certain evidence was suppressed. What Mr. Benjamin was referring to was on April 30th from 3:30 to 7 o'clock at night, a little after 7 o'clock at night, we received 5 search warrants that are in my hand. They were all prepared, I believe, by Detective Moretti. They were all signed by Judge Boger. They were all signed, I believe, over a year ago that we've never received until April 30th. Nowhere in these warrants does it make reference to the fact that Judge Murphy had suppressed portions of the items that they are now seeking. Nowhere in these warrants does it indicate that there was evidence that the affiant was suborning perjury. Nowhere in the fact does it explain why the state went to a different judge, because Judge Murphy was still sitting at the time, and decided to go to a completely different judge, not disclosing any of these facts, because I question whether or not, had Judge Bober or any judge known this, they would have taken these 5 warrants and said, go back to the original judge. And I think that is something that the court should and must ask. And it's interesting to note that on these warrants, there is in the bottom left-hand corner, despite the fact that the warrants were signed in 24, an indication that says on one particular warrant, REV-AB 1124, which I suggest must mean revised by Assistant State Attorney with the initials AB on 1124, yet they give it to us over a year and a half ago. And may I tender what I'm referring to?
Well, I didn't limit anyone in any way. I asked you 3 times, do you have any evidence you wanted to present? And you all said no, and now you're making arguments based on things that are not in evidence, and I have no idea what it is. So.
Fair enough. Do you have any objection to moving what you gave us, April 30th?
Sir, you don't have to ask him.
Oh.
This is evidence you're hearing. Yes, me.
May I introduce these 5 warrants?
Are they marked? Let's mark them as a composite exhibit. How about that?
Yes. I'm sorry.
Okay, well, that's getting done. We'll call that defense exhibit A, composite exhibit, for purposes of the Arthur hearing.
And I'd move them in there.
Do you have any objection?
Yes, Judge, just because, for the purposes only of this hearing, just because we're considering the trial testimony and the evidence that was previously introduced in the suppression, I wasn't going to ask the court to consider these new warrants.
Okay, well, over the state's objection, I will make them in evidence for the purposes of the Arthur hearing only. So if you're going to call that defense composite exhibit 1. Yes, sir, go ahead.
The reason Mr. Benjamin and I make reference to that is because this is a continuing thing that's going on with the state. Every other day, we get something new. Concerning this case that appears was in their possession for at least a year, if not longer. And as you're looking at those, at the defendant's exhibit, composite exhibit 1, okay. I want you to know that if you look at the docket sheet, it took us 4 hours to organize the warrants because they were commingled. Warrant number 1 had pages from warrant number 2 or 3. And it literally took Mr. Benjamin's judicial assistant, promoter, 4 hours to commingle all those pages because originally they came in so convoluted. Because I printed out how they came in as another game that the state is presenting on a case where our client is looking at the death penalty. This is no game. And they have a continuing obligation under Rule 3.220. Not to wait a year, not to wait a year and 4 months, but they have an obligation to turn it over in a reasonable period of time. And if the warrants were signed by Judge Bober on 3/24, I think it was, of 24, what's your excuse for not turning it over to us? It's the charges that he's facing in the murder case. First-degree murder, 2 counts of first-degree murder, and accessory after the fact for the co-defendant. I mean, I don't know what the game is. I don't know what we're playing, but it's pretty disgusting, I submit.
There was one other point before I said, in the first trial, that wasn't suppressed. There was a gentleman who took the stand, who said that Mr. Demings got out of the car and went home. He was no longer near the cell phone. That was in the first trial. That was something that the jury considered, which resulted in a hung jury. And that's something that I think is very important as we sit here today. And that's, and I'll shut up now.
So I'll try not to repeat anything that, my co-counsel said, Your Honor. But in reading that transcript, I'm sure you'll get through, I bring the court's attention to the testimony again of Mark Moretti. Talking about the change of circumstances that we learned after the trial was over, after the hearing, the first hearing on the bond with Judge Murphy, we were finally advised about what had went on with Detective Mark Moretti and Christine Bradley. Why was that so important to us? Not only the fact that the jury was not made aware of that, and they probably would not have relied on his testimony, but his testimony actually impeached the testimony of Brendan Collins, the FBI agent. So when you read that testimony, you see Judge Murphy order that we redepose Brendan Collins for that simple reason. Brendan Collins had testified at that trial, which is in the CDRs, the T-Mobile, the cell phone data is in. The state had put on Brendan Collins, basically to introduce his CAS reports. He had testified that Mr. Demings' phone, or the 9807 phone, which was left in the car, but you heard testimony from Adrian Davis at that trial that phone was left in that car. He testified that you could not, with precision, give a location on that phone. He went through the different trainings he had got from the different cell phone agencies. One of the things that he had spoken about was one of the data sheets in that T-Mobile report has a column that reads environment. FBI testified you cannot rely on that they do not rely on it for the simple reason that they don't know where they come up with the algorithms that go into that column. So when you look at that column, it shows somebody could be mobile, they could be outside. Bottom line, the expert says you can't rely on it. They don't rely on it, FBI. Mark Moretti, same guy who asked an officer to lie for him, then got on the stand and impeached Brendan Collins by saying what? That you could look at the data from T-Mobile and tell that somebody was outside, inside, or walking. He then went on the stand to give his own interpretation of what those CDR records meant. His interpretation, again, conflicted that of the FBI agent. Mark Moretti's testimony, period. We were deprived of knowing that he had previously perjured himself. we were deprived of the fact knowing that that lead prosecutor had asked him and basically covered that up. And there was a change of circumstances because that was not brought to anybody's attention when Judge Murphy had made his first ruling. And for the record, that first ruling that Judge Murphy had made, it wasn't an Arthur hearing, there was no testimony put on. I believe at the time, the only testimony that was given to the court would have been over Zoom from the family's aunt or mother. Nonetheless, getting to most of my motion, Judge. There is a case out there, Norco, and what it tells us is Reeves versus Narco, 141 Southern 3rd. What it tells us is even if the state meets its burden under Russell, and I'll get into Russell in a minute, the circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release, if the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight, is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor or GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to, one, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Demons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern actually with him not being at court because you know where he's at all the time. My proposal with the security on, with the GPS tracking, basically house arrest. It would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms and the ankle monitor. I think we could secure that there is no threat to the harm. I think the state's biggest argument today would be to assure the integrity of the courtroom, of the judiciary. And of course, they're going to bring up the witness tampering case. that case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demon's trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not, did anything. He did the right thing, Judge, and he turned himself in. I believe February 13th, 2019, 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence.
Okay.
The lawyers don't give evidence, so if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Okay, good.
You're just saying it, so go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community, to his mom, to grandma, his sister, his brother, his friends, his grandpa. We're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof of degree, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. There, I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we have met it. The state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected. Nothing further.
Yes, Judge, just responding to the points that were raised. Just so the court's aware, we have not litigated yet, but there is a pending motion to exclude the testimony of both Ms. Boutros and Ms. Bradley. It deals with a collateral matter, and we obviously believe that it's not going to be relevant to trial, but they keep raising the issue, or they repeatedly raise the issue, that Detective Moretti's suborn perjury, except there's been no finding of that, and there's no evidence of that, and actually the evidence tends to be to the contrary. Judge Murphy found no Brady violation in regards to Ms. Bradley. There were no findings as Detective Moretti's testimony during the motions to suppress. And attached to the motion to exclude her testimony is the IA clearance letter for Detective Moretti, finding that he had done nothing wrong. So when they say that he's suborn perjury, there's no evidence supporting that other than their argument and the testimony of Ms. Boutros, which they say now is going to go unchallenged, except that's also not correct. While there is currently a court order saying she's not subject to cross by the state still has the ability to impeach witnesses. So she still is going to be subject to the same impeachment that she faced during the motion to suppress.
Well, that objection, I'm sorry, Judge, that's just stating a fact, it's absolutely untrue.
It's not performing. Yeah, I don't know why I keep, right?
I'm responding to their arguments.
Out your client's family members, I'm sure she's telling me the truth, but that's not performing either. I have no idea. So, I mean, I did 10,000 bond hearings in a regular division. Family members would testify, here's our address, here's our finances, here's our ability to pay. You all don't do anything. Go ahead, Mr. Trippus. That's
So,
where.
just responding, that's all. Sorry. In regards to the testimony of both Collins and Moretti, which is contained in the transcript, Brendan Collins testified as to the cell tower location information, which does put the defendant near the crime scene as well as the hospital. Subsequently afterwards, as well as the following the path. What Detective Moretti testified to was the environmental data. As Ms. Liberty pointed out, the FBI will not rely upon that because they don't know how that is calculated. Does not mean nonetheless that Detective Moretti cannot testify to it because cell site location information does not require expert testimony, and he'd be subject to the same cross that he was in the first trial. I think that covers it as to the phase one arguments. As to phase two, if the court is going to consider exercising discretion, obviously there's two factors here. One is that the defendant charged with homicide, he's killed two people, so he's clearly proven himself.
Allegedly.
He is.
Please, one at a time. Go ahead, sir.
He's already established that he presents a danger to the community, but not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody because he did have a bond and that bond was revoked. Had Mr. Devon's been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites that all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Devons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
May I respond, Judge?
Okay, last word.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. I can give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as with the states arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day and another individual monitoring the property. They would be reporting back to not only the defense team, but the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I have other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Dimmons, while being on house arrest and a GPS tracking monitor, can abscond to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those three different combined statutes. It's protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
Okay. Thank you. Okay, listen, I appreciate the time, effort, and preparation on both sides. I'll get your written order as to both cases in the bond pending therein, for the motion pending therein. Regarding the defense motion to strike notice of appearance and all other pleadings of victims, as well as the urgent motion for order to show cause against the office of the Broward State Attorney, Harold F. Pryor and John Phillips, as well as the state's motion to remove prosecutor from witness list and for protective order. I'll ask both sides. State, I'll ask you first. How about June 4th? It's a Wednesday, June 4th.
The parties arguing those aren't going to be here, Judge. That's Joel and Stephen from our office. We're not going to be arguing those particular motions, so I'll have to consult with them. We can do June 4th for now, but
I'll set it, and if there's an issue, we'll do it.
So I can't do June
We
4th.
can't do June 4th. Okay.
I'll be gone until June 13th.
How about June 20th? That's a Friday. State, you're gonna check with your people. Defense, June 20th?
we'll check with our office, Judge. Just let the court know, I won't be here that day, but I'm not arguing those anyway, but just so the court's aware.
Defense, June 20th, 8:45? Fine. Yeah. Okay, so, this will kind of, we're gonna set all three of those motions, the defense motion to strike notice of appearance and all other pleadings of victims, the urgent motion for order to show cause against the office of Broward State Attorney Harold F. Pryor and John Phillips, Esquire, and the state's motion to remove prosecutor from defense witnesses and or for protective order. All three of those I will hear on June 20th at 8:45 a.m. The defendant's trials in both of his cases will remain as already set, September the 10th at 9 o'clock. State, anything else I can do for you regarding Mr. Devens today?
Not today, Judge, I believe we have a couple future dates and really statuses, that's it.
Yes, Judge, Mr. Klinger is good, June 20th at 8:45. The only thing is, I believe the motion for protective order is moved now because that witness list was filed just for purposes of the Arthur hearing.
Okay,
So,
well, if that's
we
so,
will need
y'all
to-
can come and
The
tell me
state will
that.
need to have that heard.
On June 20th. Okay.
No, it's set for today's hearing.
Defense, anything else I can do for you today regarding Mr. Devens?
Other than I just don't understand what you just said.
That's okay, I don't understand what both sides say. Quite a lot of it. Anything else you want me to consider today?
No, sir.
Okay, all right, Ms. Wilcox, then we're in recess until 3:30? Okay, so Division F2 otherwise being recessed until 3:30 p.m.?
All right, y'all. So I'll give y'all a real quick recap on what kind of happened there. There's so much going on, y'all. Just give me a second. I'm trying to get us over. I was taking notes, and so I apologize that I'm not actually ready for us to jump over to our next watch. But I will just go ahead and jump us into closing arguments in the Tyre Nichols trial because they started without us. So going ahead and switching over. Just 1 second. We got a lot to watch today. Sorry, y'all.
Almost cold courtroom. We are going to get right back into things. We are now with the closing remarks.
Yeah, it looks like I'll write in the comments, Ashanti. 1 second.
Thank you, Your Honor. Morning, ladies and gentlemen. Morning. I guess if you think about how hot we were at one point and how cold we are now, if you average it out over time, we've been pretty comfortable. I promise I will not use logic like that in these closing remarks. We started off by telling you that this was a case about choices. And nothing that has happened in the courtroom since we said that has changed. It's still a case about choices. And choices are something that we're very familiar with. Choices are something that we make every day. Choices are something we make every hour. We make every minute we're making choices. Even if we decide not to make a choice, we've made a choice. And in this case, Demetrius Haley made a choice for a career with the Memphis Police Department. He applied, he was accepted in the program, he went to the academy, he graduated, and then he hit the streets. As he was in the academy, he was being taught by the police department professionalism. So that's what sets a police officer apart from the rest of the public, is they have a job to do, but they have to do it professionally. There's no room for mistakes in policing. And that's why I have up on the screen right now the response to resistance continuum. This is the framework that he was taught in the police academy, and it's the framework that follows him on into the field. And what it does, it serves to protect. It serves to protect the officer who is making decisions, making choices along the way in his day. And it also protects the public because it gives the officers some certainty as to how they should behave in any given situation. When we were in Chattanooga, I think I gave you some examples of that. The physical presence, you're driving on the interstate and you see a police car parked up ahead, diagonal to where you are driving, and you figure, well, that must be, there must be monitoring traffic, and you slow down. So that is basically a command that you slow down. And just the presence of the police allows that to happen. The verbal warnings, if you're driving down that same highway and you see a sign that says no tolerance, well, that could be a verbal warning, if you will. And then verbal commands, driving down the same road and traffic is blocked. Officers are directing traffic and you go to where you are commanded to go. Chemical agents don't enter into this illustration, but they are very much part of this response to resistance continuum because they're the next step. And of course, chemical agents are things like OC spray or pepper spray or whatever you call it, that can be used to disable someone who is not complying, to allow them to be handcuffed and searched. If that doesn't work, the next step is empty hands control, and it has both soft and hard. Empty hands control, soft would be where you are leading a suspect somewhere, and the hard would be where you're actually using a fist or a foot. And those things are specifically set out in the rules that the police follow. Impact weapons, that can either be the taser or it could be the ASP baton that Officer Mills was talking about. And then finally you get to the force that no one wants to see, but sometimes is a part of policing, and that is deadly force. And understand that when they are taught these concepts, they are not taught that you follow these in lockstep. You follow these as the circumstances require. So you could go, and you'll see in a minute, an example of, you could go all the way to deadly force to begin with, and then back off of it once you see that, once you get a better idea of what the situation is. We'll see that happen. But that's what he's taught when he was in the academy, and that's what he carried into the field with him, and that's what sets the level of professionalism. Sometimes in the jury instructions, you'll see the term standard of care. Well, this would be what they're referring to as the standard of care when you have to deal with that in the jury instructions. So Mr. Haley chose to go into the rather dangerous, or relatively dangerous area of the Scorpion team. The Scorpion team had a specific purpose, and that was to use data to figure out what precincts you're seeing most crime in, and then flooding that zone for a period of time, and getting crime under management there. And then if the crime changes location, the Scorpion team changes location. But every day, they are going into the most crime-infested areas of Memphis, and they are dealing with some of the most dangerous criminals on our streets. And they're doing it professionally. They have a code. People that they're dealing with, their code is the code of the streets. And it's up to the officers to follow their code in dealing with people who are non-compliant. Enter Tyre Nichols. Now, Tyre Nichols would not necessarily be one of the people that would fit the description of the type of person that the Scorpion team is looking for.
the Scorpion team was looking for stolen cars. They were looking for people with warrants for their arrest. They were looking for large amounts of drugs, and they were looking for dangerous weapons, i.e. guns. And on January 7th of 2023, Tyre Nichols didn't fit that profile. He wasn't driving a stolen car. He wasn't, he didn't have any guns in the car with him, and he had no warrants for his arrest. So he would not be somebody that the Scorpion team would be interested in. In fact, that's sort of the really tragic part of this entire case, because practically speaking, had Mr. Nichols pulled over when he got the blue lights and submitted to the officer's questioning or whatever, in all likelihood, they wouldn't have arrested him. They could have seen a small amount of drugs in the car. They're not concerned about that. They're looking for the big fish, not the little fish. They could see some credit cards in there. They wouldn't even give that a thought. Members of the Scorpion team would. And the encounter would have ended. He would have left, and you wouldn't have to be here from Chattanooga. But Mr. Nichols had a choice. He had a choice to do what law-abiding citizens do, and that is to pull over and talk to the police, or to speed up. And tragically, he chose to speed up. Now, the Scorpion team didn't know Tyre Nichols. They never heard of him. He's never come across their radar as far as anybody can tell. The car he was driving apparently wasn't a car that had been used in other crimes that the officers may have recognized. So what was it that brought them together, the Scorpion team and Tyre Nichols? Well, one of the things the Scorpion team is good at is following clues. And whether Mr. Nichols meant to or not, he was getting off clues that brought up the antenna of the Scorpion team. First of all, when the blue light started flashing, he didn't pull over. He, in fact, not only did he not pull over, he sped up. And you can see on Officer Hemphill's speedometer how fast Officer Hemphill was having to go to try to catch up with him. He sped up, and he did something that the Scorpion team was really bewildered, because people run from the police in Memphis all the time because they know there's a no chase policy, and the police have come to accept that. And they say, well, that one got away. I can't chase, puts too many people in danger. So the police, that's not foreign to them, having somebody run away from them and never catching them. But what is foreign to them is having someone run away from them and then stop at a red light. That's weird. That's suspicious to them. And then when they saw the car at the red light, it had tinted windows, they couldn't see in it. So their antennae were up. And I want to take a look for a moment. To this stop. And as I have gotten older, when people come to me and they're upset about something, and I found the best way to deal with that is just, whoa, just slow down. Let's slow down. Let's talk about it. We'll figure it out. And so that's what I want to do here. I want to slow this down a bit and take a look at what happened. this is Officer Hemphill's body worn camera. And we'll take it up to where Officer Hemphill got out of the car at 20:24:44. And at this point, you can see Mr. Nichols' car is on the right and Officer Haley's car is on the left. That Officer Martin's car is up ahead of Mr. Nichols' car, and Officer Martin is standing at the passenger side of Mr. Nichols' vehicle. As Mr. Hemphill walks closer, you see Mr. Hemphill pull out his service weapon. Now, service weapon would be deadly force. And you'll see in a moment that not only did Officer Hemphill have the service weapon out, but as you look at Mr. Haley, he has his service weapon in his hand and he's putting it in the holster. That's because he's looked in the car and he's seen what's in there, so it's no longer a mystery. So now it falls from a deadly force incident to something much less than that. Probably a soft hands incident, which we'll see. And he holsters that at 20:24:51. Then we see Officer Haley reaching in to pull Mr. Nichols out of the car. And just as he starts coming out, we see him go back in again, indicating perhaps, now, I don't know for a fact, and it's you for the jury to figure it out, but perhaps Mr. Nichols was already starting to struggle at that point, or he wouldn't have had to go back into the car like that. But he pulls him out, and as Officer Hemphill testified, he put Mr. Nichols in the A-frame. Now remember what the A-frame is. The A-frame is the hinge of the driver's side of the car. And it's a good place to put a suspect when you're trying to handcuff them because they can't go anywhere. And you can see at 20:24:56, the back of Mr. Haley, and then the face of Mr. Nichols. And you can't really tell on Mr. Nichols whether he's turning his head to look at Mr. Haley or whether he's facing Mr. Haley. But we do remember Officer Hemphill's testimony that as he got up closer, he could see Mr. Nichols spun around and faced Mr. Haley. Well, at that point, Officer Haley is unable to get him cuffed if he's facing Officer Haley. And so Officer Hemphill comes to help Officer Haley. And then there's some grappling that goes on, and it's hard to tell from the camera exactly what's going on, but you can see where they remove Mr. Nichols from the car, and Mr. Nichols is standing there, Officer Hemphill holding with one hand, another officer on the other side holding him, and Mr. Nichols is not in a position with his arms behind his back. As we go forward, he moves over and turns toward the officers, and at that point, we don't know for sure at what point Officer Hemphill heard Officer Martin say, "Get your hand off my gun," but it would have to have been around in this area somewhere. Because shortly after we're looking at this, we see that Mr. Nichols is taken to the ground. And at 20:25:20, we see that he's clearly sitting on the ground. He has his left leg extended out in what we have referred to previously as the bladed position. Officer Hemphill's hand is on his shoulder, and Officer Haley and Martin are standing in front of him. All three officers are telling him, "Get on your stomach, get on your stomach." but we can see at 21 that Mr. Nichols is debating with them about that. You may recall Mr. Nichols saying, okay, but he was doing that with his voice, but he wasn't doing okay with his body. He was not complying with their demands. And here he is still in the bladed position, arguing with them about it at 20, 25, 21. At this point, they push him to the ground, Officer Hemphill does, and holding on to Mr. Nichols' left hand would be Officer Martin, and Officer Haley is on the other side of Officer Martin. Officer Haley then approaches Mr. Nichols at 20, 25, 26, and eventually grabs Mr. Nichols' right hand to try to get his right hand behind his back. However, and you can see him get the right hand at 20, 25, 30. However, it's impossible to get the right hand behind the back when he's leaning on the right arm. And we see Officer Martin try to force Mr. Nichols' left arm at 20, 25, 32 behind his back. But that does little good until Officer Haley is able to do the same thing with the right arm. And Mr. Nichols is continuing to resist that as well. At this point, 20, 25, 36, we see Officer Haley goes to his knees. He's dealing still with Mr. Nichols' right hand, and Officer Haley eventually decides that unless Mr. Nichols is compelled in some other way to comply, he is not going to comply. And if 20, 25, 46, we see Officer Haley pull out the OC spray and spray it. Now, what we know now is that when that happened, the spray hit Officer Haley, and apparently it hit him directly because of the level of disabling it did to him. And we see at 20, 25, 47 that Officer Hemphill now has the taser out, and he's threatening to taser Mr. Nichols. And so we know at this point in the video, Officer Haley can't see anything because he just got it in the eye with his OC spray at 20, 25, 48. And then there is a scuffle where Officer Hemphill's camera is obscured from seeing exactly what's going on. But you remember Officer Hemphill testifying that when Mr. Nichols got up, that he ran toward the police car, which was open. That was the police car he was running toward was Mr. Haley's car, and the door was open. However, Mr. Nichols did not get into that car, and at 20, 25, 57, Mr. Nichols is running on his way to Ross Road, evading the officers. At this point, ladies and gentlemen, I'm going to ask Mr. Spiegel to take over the controls, and through the magic of technology, we are going through the magic of technology, Mr. Stingle is going to help us be in two places at one time. So go ahead and start playing that at 20, 25, 57.
38, where it rains and Ross. Tyre was deployed. Suspect is running down Ross. Young male, black, slim build, blue jeans, and a hoodie. Southbound on Ross, on your right side. What's that? Yes. All right, hang on. Ready? All right, just straight. One of the problems with the back is all right, car's right in front of you. My car, go on, walk out. All right, hang on. Where's your water? Okay, I got you. Get one, get. Ready. Negative 2938. Where are my damn glasses? That back in? Yeah. I can't suggest shit to my glasses when he fight me. Later, we just saw one at that Ross. What made you laugh? Yeah. What's that? Right eye. All right, ready? Yeah. Well, right eye. That way.
Ladies and gentlemen, at 20:29:54, Tyre Nichols was caught on video on Ross Ridge hiding from the police.
Okay, I gotta find my glasses and get this damn taser downloaded. did you also read that before my taser? Thin male black, blue jeans, and a plaid jacket.
Ladies and gentlemen, at 20:32:22, Officer Bean has now spotted Mr. Nichols and has begun chasing.
You good right now? Can you lift up your hands?
At 20:32:41, Officer Bean is able to catch Mr. Nichols and tackle him. At 20:33:12, Officer Mills pepper sprays Tyre Nichols.
Martin and all them are over there chasing me. Shit, you sprayed me too, but luckily you didn't get my eyes on my eyebrow. Oh, stomp his ass.
At 20:33:53, Officer Smith radios for more cars and more officers at Castlegate. Officer 20:33:55, Officer Martin removes his body-worn camera.
They stopped his ass. Smith was calling for other cars because he was Martin chasing.
At 20:34:14, Officer Martin delivers his first kick to the head of Tyre Nichols. At 20:34:27, Officer Martin delivers his second kick to the head of Tyre Nichols. As you can see, at 20:34:41, Officer Haley leaves Ross and Rains and is on his way to Castlegate. At 20:34:49, Officer Smith radios that the suspect, Mr. Nichols, is still fighting. At 20:34:54 at Castlegate, Officer Mills opens his astroturn. At 20:35:01, Officer Mills delivers the first strike with his aspeton. 1 second later, at 20:35:02, Officer Mills delivers his second strike with the aspeton. 3 seconds after that, at Castlegate, Officer Mills delivers his third strike with the aspeton. At 20:35:14, Officer Martin delivers his first strike with his fist to the head of Tyre Nichols. 3 seconds later, at 20:35:17, Officer Martin delivers his second fist strike to the head of Tyre Nichols. At 20:35:24, Officer Martin delivers his third strike to the head of Tyre Nichols. 3 seconds later, at 20:35:27, Officer Martin delivers his fourth strike to the head of Tyre Nichols. And 2 seconds after that, Officer Martin delivers his fifth strike to the head of Tyre Nichols. At 20:35:32, Officer Haley radios and asks where they are located. Officer Mills gets on and responds that where they are at Castlegate. At 20:36:15, Officer Haley arrives at Castlegate. At 20:36:45, Officer Haley gets on the radio and requests medical care for Tyre Nichols. Ladies and gentlemen, I want to talk for a little bit about what happened once Officer Haley gets on the scene at Castlegate. Recall that what Officer Haley knows at that point is the following. He knows that there was a traffic stop at Ross and Raines. He knows that at the traffic stop, Tyre Nichols resisted. He knows that Tyre Nichols would not cooperate by putting his hands behind his back. He knows that he had to apply OC spray to Tyre Nichols and himself in the process. He knows that he has very limited vision, and he unsuccessfully chases Tyre Nichols a bit of the way up Ross Road, even though he couldn't see. He knows that Nichols got away uncuffed and unsearched. He spent time trying to regain his vision by washing his eyes out with water. He drove to Castlegate. Once he arrived at Castlegate, he saw officers still struggling with Nichols. He saw Nichols' right hand was still uncuffed, and it was turtled under his chest. He saw that Nichols, he decided to kick Nichols' right bicep to release his right hand. He warns as he's running up using verbal judo, and we're going to talk a little bit more about that, where he yells, "Beat that man's ass." He delivers the kick, and then approximately 31 seconds later, Mr. Nichols. The yelling of "beat that man's ass" has to be put in proper context. If you go back to the first video, where it was a traffic stop video at Wallace and Rains, I wrote down 3 things that you could hear Officer Haley telling Mr. Nichols at that location as they were trying to get him handcuffed. He says, "I'm going to break your shit." He says, "Get your ass blowed off." And he says, "About to knock your ass out." He says all those things on the scene at Wallace and Rains as they are struggling to get Mr. Haley handcuffed. When he gets to Castlegate, he picks up that same motif with "beat that man's ass." Now, what the state would have you believe is that, or wants you to believe, is that none of those first 3 things were said, because then they could completely take "beat that man's ass" out of context for a better story. That's not what happened. What happened was all the things that he said, they were all examples of verbal commands. They were all profane. They were all harsh. And they were all intended to do the same thing, and that is to be verbal commands under that step of the use of force continuum. Now, the state was critical of the testimony of Don Cameron about how Officer Haley delivered the kick at Castlegate. And I just want to take a look at it on the video and see if we can make any sense of what Mr. Cameron was saying. So at 20:36:15, we can see from the right hand of the screen, Officer Haley coming onto the scene. From there, Officer Haley would have a clear view of the officers still trying to get Tyre Nichols handcuffed, something that Officer Haley had started trying to do approximately 12 minutes before that. He sees that he's still uncuffed, and he sees what the situation is with Tyre Nichols' right bicep. He continues to the body. He stops, he looks, and he kicks. I'll back that up and show that again. He braces himself against one of the other fellow officers. He takes a look at the target, and then he kicks. A very specific place on the target. This is what Mr. Cameron was trying to say. It was what separated him from just being brutal and beating Tyre Nichols. Now, if you want to see an example of brutal and beating Tyre Nichols, just keep watching. Because after the kick, you see Officer Martin behind, and when he comes, he doesn't aim, he doesn't do anything, he just viciously kicks Tyre Nichols. There's a very great difference between those two kicks and those two men, and they should be treated differently. In a bit, you're going to be going back to the jury deliberation room, and you're going to have the judge's instructions on each of these offenses that Officer Haley was charged with. The context for all of these offenses, according to the state, is that Officer Haley here is being held responsible for the acts of others. And in order to do that, this is what the instruction says. The defendant is criminally responsible for an offense committed by the conduct of another if acting with the intent to promote or assist the commission of the offense or to the benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. So there has to be some involvement of Officer Haley in the decision-making process about where this enterprise was going. Now, you recall when we were in Chattanooga, you heard an illustration of this having to do with throwing rocks. And if you remember that illustration, think about that when you're looking at this, because by my memory of that illustration, every person who was held responsible for throwing a rock knew why they were throwing the rock. And I believe this case is very different than that, because this case is messy. This case is real life. This case is a case that started with officers doing a legal investigation, having probable cause to stop a motorist, having probable cause to put him in handcuffs and search him, and then everything falling apart from there when Mr. Nichols would not cooperate. None of these people had any conversations about killing Mr. Nichols. Now, that's not necessary, and the state will be sure and remind you of that, because understandings can be conveyed in different ways. But there is no indication that Officer Haley was out there at that time doing anything more than police work. Police work being trying to get a suspect handcuffed and searched. With regard to the criminal responsibility of others, it depends on Officer Haley's intent. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct cause the result. Now, Officer Haley was involved in the conduct of trying to handcuff a suspect. There is no evidence that Officer Haley was involved in the conduct that would ultimately, through criminal intent, lead to the death of Tyre Nichols. Another thing that you're going to see in the instructions is that you should give separate consideration to each defendant. You're going to have 3 separate jury verdict forms, one for each of the officers. And these officers are all judged separately. They were all doing different things out there at that time. Some things may apply to one that doesn't apply to the other. You're not to group them all together. You are to, as you're discussing the case, look at each officer separately. Second degree murder. The defendant unlawfully killed the alleged victim. They're saying that Officer Haley unlawfully killed Tyre Nichols and acted knowingly. Let's take a look at knowingly. Knowingly means that a person acts with an awareness of that his conduct is reasonably certain to cause the death of the alleged victim. Reasonably certain. The only thing Officer Haley was reasonably certain about was, in one way or another, he was going to get Mr. Nichols handcuffed within the bounds of the response to resistance continuum. That was his safety. That was his safe umbrella. As long as he remained in those bounds, he was safe. The requirement of knowingly is also established. It's shown that Officer Haley acted intentionally. Intentionally means the person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. There is absolutely no evidence that his intent was to cause the death of Tyre Nichols. He made one contact with Tyre Nichols, or two contacts. The first contact was soft hands, trying to get him out of the car and in handcuffs. Second contact, three contacts. Actually, second contact was chemical agent, because Tyre Nichols was not cooperating and he needed to disable him so that he could get him handcuffed and then start pouring water on his face. And then the third one was hard hands, and that was the foot to the shoulder. That was the only thing that you could conclude that was the intent of Officer Haley. Voluntary manslaughter. Officer Haley unlawfully killed the alleged victim, Tyre Nichols, and that Officer Haley acted intentionally or knowingly. Now we're back there to intentionally and knowingly. We don't need to go over that again because we've already talked about it. It means he had a conscious desire to act in a way that would result in the death of Tyre Nichols and the original. Aggravated assault resulting in death. That Officer Haley intentionally or knowingly caused bodily injury to Tyre Nichols, and the act resulted in the death of another. Dr. Turner told you that the sole cause of the death of Tyre Nichols was blunt force trauma to the head. There was no point at which Officer Haley delivered any blunt force trauma to the head of Tyre Nichols. He did kick Tyre Nichols in the shoulder, and Officer Turner testified that had no bearing whatsoever on Mr. Nichols' death. Reckless homicide, that the defendant killed the alleged victim, Tyre Nichols, and the defendant acted recklessly. Well, here's where we go back to our response to resistance continuum. It cannot be reckless if it is within the scope of the objective bounds that the Memphis Police Department sets out for its officers. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware but consciously disregards the substantial and unjustifiable risk that the alleged victim will be killed. Had Officer Haley gone outside the bounds of the response to resistance continuum, then he may be considered to be acting recklessly. However, he did not. At no point did he go outside of those bounds. He stayed safely in them. It says the risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances viewed from the accused person. That's Officer Haley's standard. There's the standard of care. That's your response to resistance continuum. If you can find some way that he escaped from that, And he went beyond policing, which you're not going to find. Criminally negligent homicide. That is the defendant's conduct resulting in the death of the alleged victim, Tyre Nichols. The defendant acted with criminal negligence. Sorry, messed up. That the defendant furnished substantial assistance to the person in the commission of criminally negligent homicide, and that the defendant furnished such assistance knowingly. Officer Haley was not there when the blows were thrown. There was no way that he could provide any substantial assistance. When he came on the scene, he did not know about those blows. He didn't know about Martin's kicks to the head. He didn't know about Martin's strikes, kicks to the, or strikes to the head, or kicks to the head, strikes, kicks to the head, or strikes to the head by Officer Martin. So you cannot find him guilty of criminally negligent homicide. He was not there. Facilitation of criminally negligent homicide. Now, this is the only time I'm going to talk about facilitation, because you're going to find facilitation on everything. So I don't need to repeat myself by going through each one. But the defendant furnished substantial assistance to that person in the commission of criminally negligent homicide. And he must be providing substantial assistance to be responsible for that act by somebody else. If there was no substantial assistance, he wasn't there. Aggravated assault, acting in concert. In order to convict on that, you're going to have to find as an element of the offense that resulted, what Officer Haley did resulted in serious bodily injury to Tyre Nichols. Serious bodily injury in those is described for you. Involves a substantial risk of death, kicking in the shoulder, no. Protracted unconsciousness, kicking in the shoulder, no. Extreme visible pain, kicking in the shoulder, no. Protracted or obvious disfigurement, kicking in the shoulder, no. Or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, kicking in the shoulder, no. Aggravated assault, acting in concert, you should reject. Reckless endangerment. Officer Haley engaged in conduct which placed or might have placed another person in imminent danger of serious bodily injury, and that he acted recklessly. Here we are back to the response to resistance continuum. As long as he stayed within that, he did not act recklessly, and that's an objective finding that he did not act recklessly. It doesn't have to be just somebody's opinion. Assault. That Demetrius Haley caused bodily injury to Tyre Nichols, and that he acted either intentionally, knowingly, or recklessly. We've already covered intentionally, we've already covered knowingly, and we've already covered recklessly. Does not apply to Officer Haley's kick to the shoulder. Aggravated kidnapping. This was a police action based upon probable cause to arrest Tyre Nichols. It involved handcuffing him and searching him. Once that was done, it was over with. Now, every time an officer handcuffs and searches, is that going to be a kidnapping? I don't think the state meant that. And I don't think you have to buy it, or you're going to be tying our officers' hands for time to come. Official misconduct. This is the one that I'm really scratching my head over, because I'm not sure that anything has really been put before us saying this is the official misconduct. Yesterday, I believe they said it was everything that happened from the time that Tyre Nichols ran away from Ross and Reigns. But a lot happened. Help me. I don't know what to defend on that. And if you don't know what to defend, you don't know what to convict. Reject that. Official misconduct, unauthorized exercise of official power. It's not unauthorized if it's set out in the response to resistance continuum and he stays within that framework. Reject that. Official misconduct, refraining from performing a duty. I think what they're talking about there is telling the medical providers exactly what happened to Tyre Nichols. And at that time, Mr. Officer Haley did not know what had happened because he wasn't there. He didn't see Martin deliver those strikes. He didn't see Mills deliver those strikes. So he would have no way of being able to be accused of not performing something that he was physically impossible for him to perform. Refraining from performing a duty, it sounds like the same thing to me. And finally, official oppression. The defendant was a public servant acting under color of office or employment, of course, and that the defendant intentionally subjected another to mistreatment or to arrest, detention, stop, frisk, halt, search, seizure, or disposition that the defendant knew was unlawful. If he's acting within his parameters, he can't know that it was unlawful. And it wasn't unlawful. And he shouldn't be convicted of it. When you go back to deliberate, find him not guilty on all these charges because nothing applies to the facts of this case.
All right, ladies and gentlemen, the jury, so we don't have any interruptions, is there anyone that needs a break at this time? We're going to take a brief recess.
Close the recess.
All right, so we got a quick recess on the Tyre Nichols closing. Naturally, I know we're going to jump over to...
Turning your attention, Mr. Gilman, now to the topic of visibility. Can you describe to the jury what your understanding of that term is as it applies to what you do?
Well, visibility is just the reduction of how far you can see based on some weather element, as long as we're talking about weather. So haze can reduce visibility, fog, different types of precipitation, smoke can reduce visibility in the atmosphere. But in terms of snowfall, the heavier the intensity of the snowfall, the lower the visibility.
And so from a meteorological standpoint, how is that measured?
Well, it's measured in miles or quarters of a mile, which is the standard here in the United States. And you sometimes see it in eighths of a mile, but generally with these automated systems, it would be 3/4 of a mile or half a mile, or as the snow intensity lightened up quite a bit, it may go up to 7 miles. I've seen snow falling at 10, even 11-mile visibility, which you'd hardly notice if you were out. That's not much of a reduction in visibility, but it can come all the way down to near zero.
And what was the lowest, if you know, the lowest recorded measurement as far as visibility as it pertained to this storm?
I would base that on the Norwood Airport because it was, especially in this immediate area, and they do a good job of measuring visibility, and that came down to 1/4 of a mile at the airport. It certainly may have been lower than that at times, but was on the order of 1/4 to perhaps as low as 3/8 of a mile or 1/8 of a mile between observations.
Now, sir, if I could turn your attention to the topic of temperature. How is temperature measured in your analysis as far as the data that you have?
Temperature is measured with a thermometer, and there are different types. We depend heavily on electronic thermometers now. Measure the amount of heat in the air, and we get a reading, and we generally use that reading as the air temperature.
Now, what is the difference between air temperature and road temperature?
Again, air temperature, the standard is the temperature of the atmosphere 5 feet above the ground in a well-ventilated natural surroundings. Road temperature or ground temperature is actually at the surface. So it's out beyond the atmosphere, right at the surface of the ground.
And what kind of tools are used or utilized to measure road temperature?
There are basically two ways. One way would be to put some kind of sensing device, a probe, in the surface, just below the surface. And the other way would be to use infrared radiation. So you'd mount a sensor on a pole, and that infrared wavelength measurement would give you a road temperature, a surface temperature.
Now, you mentioned earlier in your testimony that road temperature in particular is important to your clients. Why is that?
And I've heard this so many times from our clients, you can forecast or expect an inch of snowfall or 3 inches of snowfall. If it's going to melt because the road temperature is 34 degrees or 35 degrees Fahrenheit, they don't really want to do anything. They don't want to put a lot of chemical down. They don't want to hire private contractors with plows. Whereas if it's going to accumulate, especially on the road surface, they need to be prepared. And there's so much demand now on having black pavement during winter storm events. There's so many automobiles on the roadways in this area that each of these municipalities is constantly under demand to make sure they do the best job they can. And in order to do that, they need to know what the road temperature is going to be or the ground temperature is going to be in order to best have snow and ice operations to meet those demands.
Now, is there a difference, or what is the difference in the changes to air temperature as opposed to the change in road temperature?
They're different substances, so they have a different pattern of temperature change. Air temperature changes much more quickly. And of course, when we're talking about temperature, we're talking about energy, the way the molecules in the atmosphere are moving. The faster they're moving, the higher the temperature, the more energy. So depending on what is causing that change in temperature, the atmosphere is going to react more slowly. The ground will react more slowly to the change. The atmosphere will react pretty quickly, much faster.
Now, in your analysis here, what time frame again were you using, or were you measuring the temperature across?
Let
me ask it this way. You started on January 26th through the 29th, correct?
Correct.
Okay. And why is it specifically with temperature that you started on the 26th as opposed to anything else?
I was asked to start at the 26th, and I said that's a good way to go because it establishes a period of seasonal freezing ground. It typically happens in this climate in the midwinter that our ground freezes. So if you look a few days before, you get a good sense if that was the case. I mean, there have been winters, there have been months of January in recent years that we've reached 60, even 70 degrees, and nothing is going to be frozen during that time. This was not the case in late January of 2022. It was an unusually cold period, and it was important to record that.
Now, can you describe to the jury or lay out for the jury the temperature readings throughout that period of time that you analyzed?
Yes. I'll start with the 26th and just go without going through more than just a day high and low. A high of 28, a low of 12. On the 27th, the high was 27 and the low was just 9 degrees Fahrenheit. On the 28th, Friday, the high temperature reached 36 and the low was 22. And then on Saturday, the 29th, the high temperature was 29 and the low was down to 15.
Now, sir, if I could ask you specifically within that time period, a specific time period of approximately 1:30 a.m. on the 29th through 5 a.m. on the 29th, what does the data demonstrate with respect to the air temperature during that period?
From 1:30 to 5:30?
Yes, please.
On the 29th? All right, I'll consult this data from Norwood Airport if that's the way we should look at this. I would suggest to do that. And at 1:30, the temperature was 31. By 5:53 in the morning, it was down to 24 degrees.
During that time period, before that, is the temperature relatively stagnant during that time period of 1:30 to 5 a.m.?
Before that time?
During that time.
Oh, during the early part of the time. And again, this is right at Norwood Airport. It might have been a little bit colder in Canton. It certainly was colder at the Blue Hill Observatory, but I don't have a lot of that, so I'm using this.
Sure.
So based on this, it was pretty steady through around 2 in the morning. And then because of the nature of this type of storm, it's deepening rapidly. It's low pressure offshore. So the wind tends to back from the northeast to the north-northeast to the north. And that backing wind starts to draw air rather than from the Gulf of Maine, the Atlantic Ocean, the harbor, more from northern New England and Quebec. So that's a tendency of all of these winter storms to tend to get colder as the storm intensifies. And that's what we see starting to happen as you get toward 2:30 in the morning, and especially 4:30, it's down to 28, 26, and then down to 24 degrees just before 6 in the morning.
And that temperature sort of fluctuation or lack thereof, is that consistent with what you would expect in this type of storm?
It's exactly what I would expect. And this is a classic winter nor'easter, and that temperature drop is part of that. Mm-hmm.
And lastly, sir, if I could just take you back to the road temperature you were talking about before. How would you describe the temperature readings generally from the 26th through the 29th as far as what type of temperatures were recorded during that time frame that you just testified about?
As I said, it's the coldest time of the year anyway, in late January, here in the Boston area around Canton, midwinter. And this particular year, 2022, it was colder than normal. So road temperatures were dropping much of the time. They may have come up a little bit during the course of the day, thanks to sunshine during the 26th and 27th. A little moderation in the temperature on the 28th, but for the most part, there was a frost in the ground, the soil was frozen, and the temperature was unusually cold at the middle of winter.
And what impact would that have on the hardness of the ground over that time period?
Well, again, the ground was frozen, the soil was frozen, and the surface of the ground was frozen. And it would have made the ground impenetrable, that hard, as hard as too difficult. You wouldn't be able to dig in the ground.
Thank you very much, sir. I have nothing further on.
All right, Mr. Lessie?
May I approach, Your Honor?
Yes.
Thank you.
Show Mr. Lally, please.
With regard to Mr. Lally and myself, we have agreed I'd like to address the court with a stipulation, and with regard to the document we stipulated into evidence to execute measures.
Yes, Your Honor, may we approach this very briefly?
Okay.
Yeah, we didn't have a busy morning thus far. So if you are here, make sure that you like the live, and I'll have a poll up, but make sure that you like the live, make sure that you subscribe if you haven't done so already. And if you want to get a membership, we do have membership available. I will post that link in a minute here. But okay, so we watched the YNW Melly update for his motion hearing. For his bond hearing, which is the author hearing. We saw Ms. Liberty get the boots checked off of her. They basically went through the exclusionary motion, basically just to see what evidence he was going to use to consider the bond. The iCloud data was in. It sounds like they're limiting that data to when the deaths occurred and then when Millie was arrested. The defense argued Brady violations by the last prosecutor. They flat out said they playing games with the evidence, and it was a tag team effort. I do think that Miss Liberty, I don't know, she's so soft spoken. It was a little difficult for me to feel like she had conviction. I feel like in the verbal matters, right? Just verbally looking at the arguments, I feel like the state kind of won because they came across with a lot more conviction. Just because you talk with conviction doesn't mean that what you're saying is right. So, take that with a grain of salt. They offered to put him on GPS monitoring with paid deputies and basically house arrest. She wanted to bring up the jail conditions, but couldn't. And then the state argued that he was a flight risk. So there we are.
May I, Your Honor?
Yes.
Good afternoon, Mr. Gilman, and congratulations on your career up to this point.
Thank you. Good
I had
afternoon, almost.
Pardon me?
Good afternoon, almost.
I have some questions for you, if I could, please. You covered a bunch of topics on your direct examination, and I wanted to confirm some of them. As a meteorologist, you indicated that you look at a variety of areas under the larger umbrella of weather, correct?
Correct.
And one of those areas is snow accumulation.
Correct.
Another area is visibility, correct?
Correct.
Do you have a general understanding about what this case is about? Let me ask it this way. As regards weather conditions, are you familiar with an address of 34 Fairview Road in Canton, New York?
Yes.
And have you ever been to 34 Fairview, Canton, New York?
Not New York. We're in Massachusetts.
I'm sorry, Massachusetts, sir.
Yes. I've been in many parts of Canton. I don't believe I've ever been to 34 Fairview.
Are you generally familiar with that area?
Yes.
And you've mentioned the Norwood Airport on your direct testimony, correct?
Yes.
And is the general area of Fairview, is that in close proximity to the Norwood Airport?
I mentioned it's a mile away.
Right, so it's fairly close, right?
A mile.
Right, so you would expect that the readings you talked about on your direct examination would have a direct bearing and relevance to the 34 Fairview Road in Canton, is that correct?
Yes. Relevance, yes.
Yes. So what I would like to do is to draw your attention to the exhibit that was just marked, if Your Honor, we have that. May I approach, please?
Yes.
Thank you. Mr. Gilman, this is Exhibit 64. If I could hand that to you, please.
Thank you.
And you can keep that in front of you. If you could publish. Excuse me, Your Honor, may I publish?
Yes.
Thank you. If you can enlarge just, no, not the whole thing, just the chart up above, and make that as large as you could for the jury, please. That is very good. Thank you. You see where we are. And Mr. Goodman, you can either look on the screen or look on the document, whichever is best for you.
Thank you.
You're welcome. So let's start with the top, which is estimated hourly snowfall ending at. This is for January 29th, 2022, correct?
Yes.
And what does not appear on this chart, but I want to make sure I can get this as accurate as possible, would it be appropriate to, before 1 a.m., to add a 0.2 for what you mentioned on direct for midnight? You mentioned there was a little bit starting and there was a 0.2. Is that correct? Did I hear that correct?
If you want to get the total for the snowfall event, yes.
Okay, so we'll just have, if you will, an imaginary 0.2 up at the top. And what I'm going to do, sir, is I'm going to go through the hourly snowfall, because there are times that you have on your chart that are relevant in this matter. So let's start with, and just do it chronologically by time. And what I'm going to ask you to do is to do a little bit of math as we go through. If you need a calculator, I think it's going to be fairly straightforward math for someone with your skills, but take your time when we get through it. So we start at midnight, and you mentioned the concept of visibility on your direct examination, correct?
Yes.
And I believe you said on your direct examination that at midnight there was, quote, very little snow precipitation. Is that correct?
I believe I said there was very little snow on the ground.
Very little snow on the ground, and I think you used the phrase "track a cat."
Enough to track a cat, exactly.
Right. And so enough to track a cat, but a fairly small amount, correct?
I don't know how to define it any better than enough to track a cat.
Very good, sir. I'll go with track a cat.
That's the smallest amount as you can get. And again, that would be on a natural surface, not necessarily on pavement.
Right. And what would the variation be, if at all, on pavement?
Oh, a lot of factors would come into play. Most importantly, since this was a forecasted storm event, the town may have pre-treated the road. That lowers the freezing point of the precipitation. So it would, even if it was 25 degrees, it might be melting on the road.
So in terms of the factor you just talked about, for example, pre-treatment, that could cause the accumulation, the numbers here to be lower than what we're seeing on the chart, correct?
Definitely, correct.
But there's not a scenario where it could be higher, is it, at this point?
Well, there are places, especially with this kind of wind and dry, fluffy snow, that you would have drifting.
Right, but with just 0.2 inches on the ground, would you expect drifting?
No,
Okay.
Absolutely not. Not
Right,
unless I was a very small animal.
I was going to say, tracking a cat wouldn't
No.
seem to work very well if you've only
No.
got a drifting with 0.2.
I thought you were asking about the larger numbers.
No, sir. Good point. What I'd like to do is to just concentrate on the beginning here and midnight and 1 a.m. and then we'll progress down through. Okay. I want to snapshot it, if you will, starting at the very beginning. So we then move to 1 a.m., which is 0.3 inches. Correct.
Correct.
Now, if you add, and it seems like to be most accurate, to each number here, we would add a 0.2 to get the total, correct?
Correct.
So if we go to 1,
all appreciate the fact that you've gone down here 5.5 hours driving time down here and then spent over a week here listening to this. And that's really all I can say under the rules about how much I appreciate it. So let me start with my closing argument. That is Justin Smith on the proudest day of his life. He was a brand new, freshly minted cop. And that's who I represent, Justin Smith, right over there. Now, I'm not going, that's the only technology you're going to see from me today. All right. My closing argument's more going to be of what I noticed throughout the trial And you may or may not consider what I noticed to be important. And if it's not important, just ignore it. But it could be that you noticed and made note of some of the same things. And since it seems like we've been here for an eternity, I'm going to go through them. Again, use what you want and move on the things you don't want. All right, so I'm going to try to move quickly. If I even get anywhere close to an hour and a half, I give you permission to throw a rock at me, okay? Kind of like the Rock City bank robbery. Just throw a rock at me. All right, first, my notes. What happens in a city when mayors and police chiefs announce on the news that cops are not going to be permitted to chase shoplifters or burglars? Well, criminals run. They're not dumb. What happens when officers like Justin Smith get convicted of a felony because of what Tyre Nichols and Emmett Martin did? Let's be real clear. We're here because of choices, as mentioned, Tyre Nichols made and that Emmett Martin made. That's why we're here. I don't care what anybody else says. In my opinion, that's why we're here. So what happens when we convict officers like Justin Smith of felonies for chasing someone down and attempting to handcuff a suspect to assist one of his other police officers? If you're a cop, what do? Somebody like Justin Smith, who everybody knows, CU and MPD knows to be the most kind and gentle professional in that unit. He gets convicted of a felony, what's going to happen? They're going to run. The cops are going to run. Cops are going to run to Chattanooga to be a cop in Chattanooga. They're going to run down to South Haven, Mississippi. They're going to run. And maybe if they left the streets to the politicians and the preachers and the parents to police the streets, maybe the city of Memphis might learn. Your Hamilton County Sheriff has on his website, I don't know if you know this or not, your Hamilton County Sheriff, who I met, says on his website, we chase cars. He has it on his official website. You think the criminals know that? You think the burglars know that? Shoplifters, carjackers, you think they know that? It's your sheriff is going to chase cars. Just down the road, less than 10 miles from here, the DeSoto County Sheriff, Thomas Tuggle. On his website, it says, we chase criminals, we chase cars. Don't bring your crime. It says, don't bring your crimes from Memphis down here. It's just literally 3 miles south of the Memphis International Airport, DeSoto County, Mississippi. We chase cars, we chase criminals. You think they're down there shoplifting? You think they're down there breaking into 94 cars in one night? Here's some more notes that I have. That night of this arrest, who was angry? Who was angry? Well, we know Mills was angry. He said so from the stand. He said he was angry. We know Emmett Martin was angry. You couldn't be anything but angry and unhinged if you're Emmett Martin doing what he did. Was Bean angry? Nope. Remember now, when I answer a question, I'm not going to ask you a question, but the DA's office asked you a couple questions one time. I said, God forbid they actually answer some of those questions. When I ask a question, it's rhetorical. Was Bean angry? Nope. You didn't hear a peep from him. He said, come on, bro, give me your hands. Was Justin Smith angry? Listen to the audio. Justin Smith is that squeaky voice you hear. He was panicked. He had enough years on the job arresting felons, 90% of whom are armed. He had enough sense to be scared and screaming on the radio to send more cars. Was he angry? Nope. But Mills and Martin were angry. Who took breaks from OC spray, pepper spray? We keep calling it OC spray like it's, something to keep on the back of your stove. Pepper spray. You saw how potent it was. And Miss Helen said, in one breath, she says, oh, we heard how Mills and Martin were immediately affected by the OC spray. Remember saying that? But Smith and Bean didn't have that luxury. So Ms. Headley tried to make it sound like it didn't get on them. Did y'all notice in training that when they give them that one shot in the eye, there's nobody standing behind that cop that gets it in the eye? It's called backsplash or overspray. Ms. Headley told you that Martin was standing next to Mills. Go back and watch the video. No, he wasn't. He was standing next to Bean. He was standing across from Mills when he shot that spray. And Martin is not a little guy. He bailed out. Whoo! Whoo! Can't catch my breath. Mills took a 1 minute and a half break because some of the back spray got on him. At that first traffic scene, Haley's the one who sprays. Okay? Hemphill is across from him with his taser on the leg. And Hemphill gets it. It's like room spray. You're not going to be able to surgically do it, okay? And it is super powerful. For over 8 minutes, go back there and time it. Haley couldn't catch his breath. He couldn't see. He was prying his eyes open to get water in it. Hemphill, while Mr. Leffler was reading out the times of what was going on over at Castlegate, Hemphill was still coughing up a lung. Hacking and coughing on the... He only got a little shot. Bean and Smith didn't have that luxury. They let go of that man on the ground with a handcuff on him. Somebody's going to get shot. It might be Nichols, because if he gets up with that handcuff and starts swinging it. Or a cop's going to get hurt. Miss Headley actually had the temerity to look you people in the eye and say that Bean and Smith were holding the victim Nichols down on the ground. Remember saying that? Don't answer. Mills stated from the witness stand that Bean and Smith weren't holding him down to be holding him down to get punched, kicked, or whatever. Mills said that those two guys kept their hands on Nichols to keep him on the ground to get him handcuffed. What else could they do? Did Smith and Bean get a break? Haley and Hemphill got an over an 8 minute break. Mills took a 1.5 minute break. Those two guys never got a break. Mills testified that days after this happened, Justin called him on the phone. He testified to it. Mills did. Mills did. That's the state's witness. That's the state's witness that they called to prosecute these men. Mills said that Justin called him up and said, man, I just heard that there were kicks. And I'm going to call the lieutenant about it. He was mad. I think he used dirty words. I think he said it was effed up. Justin didn't know about the kicks. And they would have you believe, how could they not? Bean's body cam was right there on the ground. It caught every one of the kicks. Again, their witness Mills testified that he didn't see any of the kicks. And by the way, Mills is the one in the video with nothing in his hands, no hands on a suspect, staring at Martin and staring at Nichols. And yet he said, I didn't see the kicks. Justin and Bean, and I don't mean to drag Mr. Perry's client into it over and over again, but let's face it, Justin and Bean are bent over at 90 degrees, face full of spray, and blind and deaf and suffocating, trying to get this unknown suspect who they got called out on, had already fought off 3 cops. They have no idea if he has a weapon. Mills didn't see it. And Miss Haley said there were 7 times that they could have stopped these kids, by these things, stop. Justin Smith had his hands full. And Justin Smith has a history. You heard it from the witnesses, the character witnesses, that he is incapable. It is not in his nature to allow another officer to abuse a suspect. He's just not going to do it. The judge has instructed you on the law that when it comes to character witnesses, if someone is of good character, it strengthens the presumption of innocence, which is the strongest presumption in American law. Because good people, remember what Mr. Hagman said in Chattanooga, and it's been repeated ad nauseum here, good people do bad things. Well, we're not here about good people doing bad things. We're looking at here people being charged with felonies. Good people do good things. And Justice Smith didn't do anything different that night. He was doing the best he could to help Darius Bean get handcuffs on and get Nichols in custody. Miss Headley, I have to take my hat off to her. Miss Headley had me, even though the judge says she shall not have any sympathy, talking about sesame chicken. Sesame chicken. Rovon Wells was making sesame chicken that night, and Tyre rubbed his belly saying, Justice Smith did not do anything to Tyre Nichols. Tyre Nichols made choices. You've heard about them. Speeding, running from the police, blue lights, fighting at this first scene. Did you hear what he said? He looked at these cops and said, get your ass out of the car. He said, y'all are really doing a lot tonight. Stop. Don't do that. I'm just going home. When they're saying, get your ass on your belly. Right? Tyre Nichols made these choices. It's isn't about sesame chicken. It's that Tyre Nichols somehow getting 750 pounds of men off of him and running to the next street over and hiding behind a Toyota 4Runner. Wiping his face, wiping that spray off. And then he happens to be seen by Mills and Beatty. These guys have guts that I don't have. Okay? I flew Army helicopters for a long, long time. I've never had a shot made at me in anger. Okay? These guys, over 2 and 3 year periods, are making over 1,000 felony arrests themselves. 80 to 90% of them have hidden weapons on them. Frankly, when Emmett Martin announced he's got to hold my gun, he's got my gun, in other circumstances, I'm surprised somebody gets shot and killed right then. That's a deadly force situation, you heard from the experts. Instead, they're trying to talk him into getting his arm behind his back. Dude, get your arm behind your back before I break your shit. Foul language. This is not some guy worried about going home and eating sesame chicken. The investigation. Let's talk about this investigation. Whew. Chuck Baker comes, impressive fellow from TBI, and I asked him, whose decision was it to return Kelly Rogers' pink American Express card? Not return. Did I say return? They didn't return it. It wasn't Tyre Nichols' American Express card to begin with. Whose idea was it for you to give the American Express card and all these other cards to Tyre Nichols' mother? And he goes, well, he took his instructions from the DA's office. That man right back there. He took his instructions from the DA's office, Mr. Mulroy. Let me offer you a suggestion. You don't like it, if you don't believe it, throw it out. If they call Kelly Rogers up and say, we have your American Express card, would you like to come down and get it? Don't most owners of the credit card say, where'd you find it? Well, we found it in Tyre Nichols' car. There was a better than even chance that Kelly Rogers was going to tell the media, my credit card was found in Tyre Nichols' car, the one that's making worldwide news. And there goes the narrative right down the commode, right? just a victim waiting on Sesame Chicken. Instead, they gave Kelly Rogers an American Express card to Rovon Wells. Is she going to go to the media saying, oh, by the way, they found this American Express card in my son's car? No, she's not. That story ends. Don't tell me this wasn't directed. Don't tell me this investigation was not focusing on those cops. They take DNA swabs from their mouth, they take their shoes and their boots, cut them up for DNA, and they don't go down to St. Francis Hospital with a search warrant for Tyre Nichols' blood. See if he's on anything. He's got 5 narcotics officers saying he's high as a kite. And they don't go down and get a search warrant. Don't tell me this investigation was not tainted. Somebody told me that y'all are going to be jealous if I referred to my iPhone because y'all haven't had an iPhone for a week or two, so bear with me. Now, this is not one to throw a rock at me, okay? I'm going to read you a headline. Headline is a public record. A newspaper is considered a public record under the law. Okay, I'm just going to read you the headline. Memphis has broken homicide record. New numbers show. November 20th of 2023. 11 months after this. Right? Keep up. That's November 20th of 2023. CNN headline. CNN. Memphis mayor meets with gang leaders to request ceasefire in effort to curb city's gun violence. March 3rd of 2024. Mayors are meeting with gang leaders to stop gun violence.
Yeah, maybe you're crazy.
Yeah, so anybody that's here that's looking for the YNW Melly trial, it's already aired. We've already watched it. So if you want to watch it, you can rewind the live and you can watch the hearing as we watched it. Right now, that court is in recess and will not resume until 2:30 Central Time. So if that's what you're looking for, it's already aired. We've already watched it. You need to rewind to do that. Right now, we're watching the Tyre Nichols murder trial closing arguments. I'm sure after he finishes up his argument, which is crazy in itself, the jury's going to get their instructions, and then we'll be on verdict watch. We are also on verdict watch for the Christopher Scher trial, where he unalived Patrick after that traffic stop, and he was when he was drunk. So we are on trial watch for that. So quite a few things that we've got going on today. So just let me know if you got questions.
Take that time off my schedule. All right, now, you people live in Chattanooga, these headlines that I read talk about our crime rates. That's probably not a single surprise to any people in Hamilton County, but crime rates in Memphis, especially in light of the evidence that 80 to 90% of the people that they try to arrest all have hidden weapons. These crimes, where we're breaking records for violent crime, all predate Scorpion. And since these guys are where they are, crime has continued to go nuts. It's a matter of public record. It's a matter of your own knowledge in your own head when you come to Shelby County, okay? So what do we do? What do the leaders do? they form a scorpion team. They take statistics, which I thought this case was about. They take statistics and they move them to dangerous areas of Memphis. And they leave them there for a week with the sole purpose of removing criminals with, felony arrest warrants, stolen cars, drugs. Get them off the street. They do it for a week or two, and then they got to move on to the next precinct because they get the crime down in that precinct for a little while, and there's another precinct going nuts. So they have to go over there for a week or two. Remember in my opening argument, I said these cops serve in the most dangerous unit in the most dangerous city in the United States. That goes to their mindset when they attempt to pull a car over that keeps going. That's in their mindset when they tell Nichols, get out of the effing car. They don't use language we're going to use at church. And Nichols pulls back against him and they pull him out of the car. That's what's on their mind. Let go of my gun. That's what's on their mind. Justin Smith watching Tadarius Bean go down a dark street. Don't believe me, believe Mills. He didn't even know what street they were on. A dark street. They're chasing an unknown fleeing suspect. Bean's by himself, tackles him. Justin, with a blown out knee, gets out of his car to go over and help Bean, handcuffed. At that point, why did Tyre Nichols just say, all right, woo, you got me. I'm done. Remember, Keith Perry said, the real gangbangers, the real thugs know to put their hands behind their back, right? Right? It's going to go quickly and be over. These were not a bunch of bullies, monsters. Mr. Adams said they're not monsters. Well, of course they're not monsters. They're doing a job that none of us in here have the guts to do, to try to keep the rest of us safe. All Tyre Nichols had to do was, all right, man, you got me. He might have spent a little time in jail for some of the stuff they might have found, but he wouldn't be dead. Those headlines I told you about, the things you know about in your own mind about Memphis, do you think Justin Smith knew those things when he decided to go to work on January 7th with a blown out knee instead of staying at home and nursing his knee? This guy with a college degree, with one of the most outstanding reputations at NPD and OCU, he knew what the risks were when he went into work. And he faced it. I don't have those guts. About the only thing Justin is guilty of is being naive. He probably thought he was making a difference. He literally was risking his life in reality every night to arrest people, sell dope, carjack cars, steal guns, credit cards, treating these people with respect. That's what they said about Justin. He's dealing with the worst people in Memphis. And Wojciechowski, who was his lieutenant and actually made arrests with him, with pepper spray in their face. Nemak, who is the old school guy, he says that Justin's new school. That is, he treated the suspects with respect. So is he going to change his spots that night and treat Tyre any different? No. This is Emmett Martin and Tyre Nichols' doings. John Keith Perry said he was going to beg you at one point in his closing argument. I thought to myself, don't feel like a Lone Ranger. I'm going to beg as well. I'm going to beg 12 people that end up on this jury to stop the misery Justin Smith has been going through, being charged with second-degree murder, aggravated assault, kidnapping, official misconduct, and official oppression. End it. Go to the jury verdict form. I'm going to read you the pages, make it hopefully better for you. And check the box, not guilty. and let Justin try to get some semblance of order. He'll never be a cop again. There's nothing we can do about that. If you're involved in the Tyre Nichols arrest, you're not ever going to be a cop again. Convicting Justin Smith of anything. By the way, a lot of times these people, these governments, they charge people with all these charges, right? And some of them sound pretty harmless, like official misconduct. That sounds like the clerk at the license plate place taking $5 out of the till. It's a felony. Official misconduct is a felony. Official oppression is a felony. Do not convict Justin Smith of any of these charges. Next thing I'd like to tell you. When I represent a client who, let's face it, probably did do something they shouldn't do, I love lesser included offenses. Because I figure, well, the jury might cut me some slack, and instead of convicting them way up here, they'll convict them way down here. Okay? The state is the one wanting you to go. They're hoping that you'll get back there and you'll negotiate, you compromise, and say, well, you know, I'm not guilty of murder, but let's tag him with this. That's their idea. I'd just soon try Justin Smith on murder. But I'm forced to defend him on all those lesser charges, which is just a game, in my opinion. It's just a game.
Your Honor, this whole, if Your Honor could give some type of instruction to the jury that the lesser included are the law in the state of Tennessee, and that's why Your Honor has included those in the jury instructions. That's not something that the state did.
I'm going to allow them to finish the closing arguments and I'll give an instruction.
Thank you. Lesser included offenses many times will have a jury do what's called a negotiated or compromised verdict. I'm asking you not to do that. I just don't know how much clearer I can make it. I'm asking you not to do that. Now, let me go to the DA's closing argument. And I'm only going to do some of the high points. I'm not going to do all of Ms. Headley's closing argument. Okay, just some high points that I noted. She said that Tyre Nichols, after looking forward to Sesame Chicken, said when he got out of his car, I'm just trying to go home. If he'd have done what the officers told him to do, he could have gone home that night, or at least some night quickly in the future. But he didn't. Instead, Ms. Headley makes it about the officers. Should have the officer just said, oh, well, you're about to go home? Go ahead and go home. Is that what you want? She took issue with my phrase, tail whip. It was when I was asking Mills about you getting your tail whipped. These guys face felons every night, and they can't keep this kind of control. And by the way, this is the second scene. The first scene, he's already whipped their tails and got away from them. So that was my phrase that Ms. Headley took issue with. These officers clearly were in over their heads with this one suspect, Tyre Nichols. Mills said he was angry when he used his baton. He was being honest and candid. But then he went on to say, yeah, while I was angry, if Tyre had just given us his hands, I would have not have paid. Even though he was angry, Mills said that if he had just given us his hands, I would have never struck him. You can't believe Mills 1 minute and disbelieve him the next minute. That's their witness. I'm not going to spend too much more time on the DA's office continually saying that Bean and Smith were holding Tyre Nichols down, and they even played it to you in slow motion. That's not what Mills said. Mills said they weren't holding him down for beatings. Hold him down trying to get him handcuffs. That's their witness. Ms. Headley stated, and I should have objected, Ms. Headley stated they had to have felt or heard the kicks. Remember her saying that to you? She's telling you that they had to have felt and heard the kicks. I didn't object, that I wrote this note down. Their witness, Mills, says he didn't see the kicks. Their witness, Mills, says he heard the thud, and when he saw the second punch, he turned away and walked away because he didn't want to see it. Smith and Bean didn't have that luxury. First of all, they didn't see it, and second of all, they could not let go of this suspect. This is crazy to evaluate this case on slow motion video in a 70-degree courtroom versus out there on a dark street. This is crazy to evaluate them criminally this way. I'm just going to take my time. I don't mean to keep you hungry, but Ms. Haley said Mills and Martin reacted to the OC immediately. Well, what are we going to do? Punish Bean and Smith for just sucking it up and fighting through it? So Ms. Headley's saying they couldn't have felt or tasted or smelled the OC spray because Mills and Martin reacted to it immediately. Ms. Headley said this to you in closing argument, and I did not stand up and object. It said, cops had no idea about the cards and the dope in the car, and the mushrooms only weighed as much as $2 bills. Cops could have known about it. But you know who did know about it? Tyre Nichols knew about it. It's okay for Ms. Headley to tell you what the cops didn't know. It's okay for me to tell you what Mr. Tyre Nichols knew. He knew what was in that car. He wasn't scared of those cops. I think he probably got scared of them. He wanted to get away from that car. If he gets away from that car, there's a hope. Stay out of jail. Ms. Headley said that Tyre Nichols ran because he was scared of the police. She said, I don't know how she knows that. She went on to say that we picked on Robert Long too much. That's a young EMT, stood there like I'm standing, while Justin Smith is saying, man, his oxygen's low. His O2 is low. Where's your bag? You heard Justin. There was only one person trying to care for Tyre Nichols out there. It was Justin. That's not to the detriment of the other officers. I'm just saying. She said we picked on Robert Long. And she said, if they hadn't done what they did to Tyre Nichols, Robert Long wouldn't even be out there. Remember she said that to you? And I wrote, if Nichols had not done what he was doing, Robert Long wouldn't be out there either. If he would just get out of the car, say, why are y'all messing with me? Here. He could have gone out and hired himself a really good lawyer for mistreatment or whatever. Instead, he wants to say, y'all are really doing a lot tonight. Stop. Don't do that. I'm going home. The whole time he's got three really big men with big items to hurt you, saying, lay on your belly. He didn't do it. Now, we're getting to my closing argument, and it's only 3 pages long. Hopefully, I've covered a good bit of it. Justin Smith's reputation was that of compassion, protection of others. I've talked to you about character evidence, strengthening the presumption of innocence. I won't cover it anymore. By the way, Mills actually ended up being one of Justin's character witnesses. Mills said that Justin was calm and shared the same values with him. Or is not going to take advantage or harm a suspect. Can't believe that and then not believe something else. Mills went on to say he didn't see the kicks, didn't see a good many of the punches. He stated that he heard no words during the during the Castlegate thing. He said the first time he heard the words was when he watched it later on video. Remember that? That confirms what Zwicky said. that when you're in a critical incident, you're scared. In a critical incident, your field of view goes to 2 degrees. You reduce that more with no glasses. You reduce it more with OC spray. You're scared to death hanging on to a handcuff. You don't hear. That's called auditory exclusion. Justin was in the fight of his life. And sitting here in 70-degree weather, looking at a video saying, well, that doesn't look too bad. It's impossible for us to get in the shoes of those officers that night. I was a horrible baseball player. Dealing with patients has to be hard. Dealing with wait staff, people has to be hard. Dealing with second graders must be hard. How hard for these cops? And we're wanting to convict them of felonies? I told you a minute ago I was going to tell you the pages. In that big, long jury instruction, each of the 3 defendants, they go through the 7 charges and the lesser included offenses. I would tell you that Justin's charges, where you mark guilty or not guilty, is at page 72, page 75, page 78, page 81, page 84, page 87, and page 90. Page 72 is second-degree murder and the lesser included offenses. Please mark not guilty. Page 75 is aggravated assault. Again, please mark not guilty in the lower left-hand corner. Page 78 is aggravated kidnapping. Same. Page 81, kidnapping with a deadly weapon. Same. 84 is official misconduct. Page 87 is official misconduct refraining from a duty. That has to be about providing medical care. When you read the charge and you've heard all the evidence, that's the only thing it could possibly relate to. Mr. Leffler, you might recall, said yes, he struggles with that as well. And page 90 is official oppression. I want you to pay close attention to the following words, if you will, please. Knowingly, and the definition for knowingly, which remember includes reasonably certain. Knowingly, reasonable certainty, intentionally, unlawfully. These words have meanings within those jury instructions. They're very important. They're very, for lack of a better word, they're very intentional. They're very purposeful. I don't think you're going to find Justin Smith had a purposeful bone in his body to hurt Tyre Nichols or to allow anyone else to hurt Tyre Nichols. There's no way sitting in this courtroom looking at grainy video and pieces of moving body-worn cameras that Justin is guilty of a crime beyond a reasonable doubt to a moral certainty. Justin's character and his nature from these different witnesses, I ask you just to answer this in your own head. Would Justin hurt a suspect? Would Justin lose his temper? Would Justin allow someone else to hurt a suspect? Will he encourage or assist someone else to hurt a suspect? Listen to the audio tape. You'll hear Justin Smith on the radio at least 4 times, squealing, squeaking, begging for more cars, more help. Send more cars. He's still fighting. Send more cars. Justin Smith does this every night of the week. Justin Smith was probably for the first time in 3 years in OCU scared about what was about to happen. But do you call other cops and other witnesses to come over and witness you breaking the law? If Justin was going to break the law and hurt Tyre Nichols or allow someone else to hurt Tyre Nichols, would he call for more witnesses to come over? Well, of course not. That's common sense. Common sense, to me, is reasonable doubt. We've gone through all of Nichols' choices. I won't go through them again. I'm gonna go through my witnesses real quick. Curtis Tate is the first witness I called. He's the one who said that if somebody's mother or sister was on the side of the road with a flat tire, Justin would be one of the guys to stop and help fix the flat tire for a stranger. That was Curtis Tate. Jared Zwicky, he was my expert. I don't think anyone took issue with his expertise, candor, and fairness. Okay? Jared said everything Justin did was lawful that night. And then he went on to talk about how dangerous the situation was. And then he went and talked about physiological struggles that cops have in critical incidents. Brian Nemack was the old school guy that Mr. Hagerman cross-examined and said, y'all all sit around and tell war stories, and some of it's pretty violent. It's old school, right? Nemack was on and said, yeah, I've been doing it a long time. Yeah, Mr. Hagerman, you and I have had those kind of conversations. And I asked him, I said, but is Justin Smith one of those guys? No, he's not. That's what he said. But he went on to say he was one of the best I had. And he said, Nemack said about Justin, he treats the suspects, the arrestees, with respect. Nemack said that. The old school guy, he probably took part in some of this kind of stuff back in the day. That's what he said about Justin Smith. Nemack is only recently retired. He's come here, so did Tate, working for the MPD, talking about Justin Smith. That's pressure. That's guts. Mark Wojcicki, that's the cop, OCU cop, physically fit looking dude, turned preacher. You heard what he had to say about him. He would not back off with Mr. Hagerman saying, good people do bad things. Good people are capable of bad things. The preacher in him says, yeah, we're all capable of bad things. But then he said, but it's not in Justin's nature. And that guy has been in arrest scenes, fights with Justin Smith beside him. And that's what Wojcicki said about him. Garrett O'Brien came in. He's kind of a stud too. He comes in. He had to hit a house on a search warrant. Some stolen cars, drug stuff, they all do in the dark of night. And he said that even though it wasn't his case, he could call Justin and Justin would pay attention to what O'Brien's case was about and took it seriously and went and hit the house with O'Brien. And then when O'Brien was about to take $5,000, that O'Brien thought was supposed to be grabbed by the warrant, Justin reads the warrant and says, that money back. It's not included in your warrant. It wasn't even his case. Hemphill called him kind and gentle. Then I said, did Justin try to keep you away from the wrong kind of people? Hemphill said, yes. Desmond Nichols, their client. He made fun of about how blind he was. But if Justin took his glasses off, he's blind as a bat. This is not a dark street. Those he sprayed in a fight for a handcuff. Mills, their witness, said that Justin was blind as a bat without his glasses. You heard all the audio and video. There was a fight. They didn't know who they were fighting. They had no idea about the suspect chicken. They had no idea what was in his car. Granted, just trying to get this guy in handcuffs. I didn't do that. I don't think. Did I do that? Oh, I'm sorry. I wouldn't do that too. Go check the box, not guilty. On those 7 pages I gave you, please. Return Justin Smith to his wife and kid. Let him somehow try to start his life over. Convicting him of a felony is not going to bring Tyre Nichols back. That is unfortunate. Any creation of God that leaves before its time is a tragedy. Tyre Nichols is gone. Convicting him of a felony will not bring Tyre Nichols back. Emmett Martin is in prison. I don't know any of us going to live long enough to ever see Emmett Martin back. Emmett Martin's in prison for what he did. Mills, he's already pled guilty. do not convict Justin Smith of these felonies. Please. Thank you for hearing me.
Ladies and gentlemen, as we, of course, somewhat mentioned, within the law, anytime a person is charged with an offense, that particular offense has already built into it lesser included offenses or lesser crimes. When a person is charged with an offense, rather than list off every single offense that is included in the offense, they just are charged with the highest, and then everything within that charge is considered a lesser included offense. The court is the one that has elected which offenses are going to go before the jury for their consideration. This is not something that the attorneys in and of themselves make the decision. Ultimately, the court is going to be the decision maker in what the law that is presented for your consideration is going to be turned over to you. So I just want to make sure any statements referencing one side or the other as being the person that's requiring this to go before you all, I want you all to understand that I am going to be the one that provides the law to you, as I instructed at the very beginning and will continue to instruct to you. The law comes from the court. And so any instructions that you all have come from the court. All right. Before we begin with the last portion, as we talked about at the very beginning, because the state has the burden in this case, now that the defense has finished their closing arguments, the state will have an opportunity to present a rebuttal argument. Is there anyone that needs a break so we don't have any interruptions during that rebuttal argument? All right, proceed.
Two soccer ball kicks to the head, 3 baton strikes, 5 haymakers, and 2 more kicks. That's not about making an arrest. That's not about getting someone in handcuffs. That's not. That was about Tyre Nichols making these officers run. These officers pepper spraying themselves. Because at Ross and Castlegate, Tyre Nichols was not resisting. He was trying to survive. You all are able to see that in the video. We're talking about the choices of Tyre Nichols. We're talking about the choices of Emmett Martin. Well, all 3 of those men over there made choices and could have made choices that night. Should have made choices that night. They could have chose to stop it. They could have made a choice to stop it. In fact, they had a duty to intervene. They had a duty to stop it. And not one of them did. So the defense attorneys, during the course of this trial, the last 2 days, have said a lot. They said a whole lot. They've thrown a lot of smoke and mirrors, but smoke and mirrors do not equal reasonable doubt. And I told my boss under my big boss that I wasn't going to talk about their smoke and mirrors. I was going to focus on something different. But some of the smoke does need to be cleared up, and some of the mirrors do need to be broken. And like Mr. Zumot, I'm not going to talk about all the smoke and mirrors because it was a lot. But I am going to hit the highlights, okay? So first, before we can get into anything, we got to talk about this idea of a tainted investigation. We've heard that for days now. They said TBI and the district attorney's office and the FBI, the Department of Justice, everybody was colluding and working against these men. They will have you believe because TBI got involved and my big boss somehow was driving Hickory Hill January 7, 2023, saw these officers doing what they were doing and saying, hey, this is gonna be a great news story. That's not what happened. In fact, look at the policy, Memphis Police Department's policy. You'll have it with you. In cases where individuals are in custody and are critical or dead at the hands of law enforcement, TBI has to get involved. But that can only come at the request of the district attorney. So who knows about what happened to Tyre Nichols back on January 7, 2023? TBI doesn't. My boss not out riding. Miss Wells has collapsed on her son in the hospital. She's not calling my boss to make the call. Who knows? Who else is a part of this conspiracy? MPD? Is it reasonable to also believe that MPD made the call to my boss? Hey, we got somebody critical at the hospital doing an arrest. TBI comes and clears out their hospital scene. Because that's what Ms. Wells said happened. For those officers who rode in the ambulance with Tyre Nichols, who were still at the hospital at the time he was there, cleared out. And then a tainted investigation. But when TBI gets involved, give them what they want to believe is their best piece of evidence. These mushrooms and these credit cards that somehow justify Tyre Nichols being beat to death. Mushrooms that were found in the trunk of his car. Mushrooms that you heard Dr. Ross say weren't even in his system. What did he have in his system? Alcohol, well below the legal limit. I think it was 0.4 grams. I don't know, 0.04. But a tainted investigation. Smoke and mirrors. Let's talk about what this is not. Because we told you back in Chattanooga, this is not about a group of men who met on Flicker Street and said, we're going to go out and kill somebody tonight. This is not even about those men meeting up at Ross and Raines or Ross and Castlegate saying, hey, we're going to agree to do something to Tyre Nichols. If there were a case, it would be a what? First degree murder case. Nobody is saying it. Would it also be a conspiracy case? Nobody is saying it. But what it is a second degree murder case, and it's a criminal responsibility case. And we're going to talk about what that means. And then the gun. Tyre Nichols grabbed Martin's gun, put his hand on his gun. You heard from Mills, later said it might have been my gun belt. All of it requires us to take the word of Emmett Martin. But we know, because we see on the video, 1 minute it's a traffic stop, 1 minute Tyre Nichols got out and took a swing, got on 1 minute. That's whose word we're supposed to take. You rewind the video of the traffic stop back. You tell me if you hear about a gun, but beyond that, if there was a gun, and if they believe that he grabbed the gun, which would justify and increase this situation, as the expert said, if that was the case, who was at Ross and Raines when that happened? We got Hempfield, we got Martin, and we got Haley. But guess what? Nobody got on their radio and put out, hey, yeah, pepper spray deployed. Yeah, Taylor deployed. Yeah, he's running this way or that way. Nobody got on their radio and said, hey, he went for an officer's gun too. I mean, wouldn't that be information that you want your fellow officers to know? If they're pursuing somebody who you believe is so dangerous, who you believe just overpowered, what was it, 700 some pounds of a man? Wouldn't that be information you would want somebody to know if it was true? Smoke and mirrors. This notion, and I want to be clear what this is not. This is not an indictment against our police officers. This is not an indictment against police officers who get out, who do their jobs, who put their lives on the line. Nobody is saying it's not a dangerous job. Nobody is saying that it doesn't take bravery. No one is saying it. But because it's a dangerous job, does not mean that you are immune from making criminal decisions. So yes, we can talk about the language police officers use, the actions police officers use. Me and Mr. Hagman can agree to disagree about the verbal judo. And they snatching them out the car. I'm gonna blow your ass off. When they have them on the ground, I'm about to break your shit. We can agree to disagree. Okay, tough job, rough language, cool. Nobody is being charged for that. They have him on the ground. He's hurt now. Guns drawn. You about to get your ass blowed off. He's hurt. We about to break your shit. He's hurt. Pepper spray him. He's hurt. He, being Tyre Nichols, has hurt. Take him. Well, what's next? What's next? Wait on him to pull the gun back out. He takes off running. Tyre Nichols should have just stayed there. He shouldn't have really resisted. He shouldn't have ran. Okay, but he did. He ran. And at Ralston Castlegate, he's tackled to the ground by Tadarius Beans. Nobody is saying Tadarius Beans should not have tackled Tyre Nichols. He's not being charged for this. None of these officers are being charged for this. But as Tyre Nichols is on that ground, and Emmett Martin delivers that first kick to Tyre Nichols' head, it's a flag on the play. Whoa, 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 wait a minute. That kick to the head, look at police policy, Memphis police policy. It's considered deadly force. So when you apply this deadly force to this man who's on the ground, he now becomes a victim. He now becomes a victim. But nobody intervenes. There's more kicks. There's more kicks. There's more punches. There's more punches. There's more kicks. That's why we're here. That's why we're here. I believe it was Mr. Perry who talked about split-second decisions. A split-second decision will be somebody running through a red light, making a decision, should I beat it, should I not, should I beat it, should I not, trying to beat it and having a car accident. That wasn't this case. Tyre Nichols was beaten for 2 minutes, from first kick to last kick, for 2 minutes. And in between that time, each one of these officers sitting in this courtroom could have done something. Each one of these officers could have said something. This was not a split-second decision. Smoke and mirrors. And maybe the best smoke and mirror of it all is this whole notion that these officers were just trying to handcuff Tyre Nichols. Tyre Nichols could have just put his hand behind his back, say, you got me, you got me. But when they first approached Tyre Nichols, what did he say? All right, all right, all right, threw his hands up. So how do we even get on the ground? But even when we're on the ground, you know that character witness who came and said and testified on behalf of Mr. Smith, who talked about the dangerous arrest he made with Mr. Smith, who talked about the person who had been pepper sprayed. He was on one side, another officer was on another side, and guess what Smith did? He grabbed his feet and they were able to get him handcuffed. Guess what they could have did when Tyre Nichols was on that ground? They could have grabbed his feet and been able to get him handcuffed. But nobody said grab his feet. Nobody said, hey, it's four of us out here. You get one arm, I get one arm. Somebody standing on his feet. And to the very end, until the actual patrolman came in and grabbed his feet. That's how he got handcuffed. It wasn't because Haley and Martin kicked him again. It was because somebody out there had the sense to say that. And Justice Smith knew how to because he had done it before. This wasn't about trying to get him handcuffed. And we know that because we know witnesses have testified, defense counsel have gotten up here and said it repeatedly. When the handcuffs go on, the fighting stops. When the handcuffs go on, can't do anything, can't hit them. Well, isn't it reasonable to believe that these officers weren't trying to get those handcuffs on him because they wanted to punish him for running, because they wanted to punish him because they pepper sprayed themselves? Tyre Nichols didn't grab a pepper spray can. They're upset, they're angry. They don't want those handcuffs on. It's an illusion for the body cameras that are still on, the ones that people haven't took and snatched off, the ones that haven't fallen off during the scuffle. They're asking for his hands, but they have his hands. They're asking for his hands as two officers have his hands and he's being punched. This is not about trying to handcuff Tyre Nichols. But that's what they want you to believe is my guy was holding him, so there is B, and Justice Smith just holding him, trying to get him handcuffs. They didn't have any intent to hold him so he can get punched in the head. Well, guess what that still sounds like, defense attorneys? That's still minimal facilitation of second-degree murder. That's not what this is. It's not just facilitation of second-degree murder, not just them holding his hands for him to get handcuffed. This is second-degree murder. And so how do we get to that? Because all week, up until now, all week what it's come down to is that those men to see what Emmett Martin was doing, to hear what Emmett Martin was doing, if they were criminally responsible for Emmett Martin's actions. And all week, everybody has been trying to stay away from what Emmett Martin did, right? I think Mr. Leffler got up today and he read from you page 47 of your jury instructions that said, considering multiple defendants, you should give separate consideration to each defendant. Absolutely. Absolutely you should. But that goes along with criminal responsibility. You reconcile it with criminal responsibility because on page 58, where we're talking about criminal responsibility, it says the defendant is criminally responsible as a party to second-degree murder, aggravated assault, aggravated kidnapping, aggravated misconduct, and official oppression, if the offenses were committed by the defendant's own conduct, by Sedarius Bean's conduct, by Demetrius Hayes' conduct, by Justice Smith's conduct, or by the conduct of another for which the defendant is criminally responsible or both. So we don't get to just throw away Emmett Martin. We don't get to just throw away Emmett Martin. Yes, we evaluate them separately. That means evaluate if Sedarius Bean was criminally responsible for Emmett Martin and everybody else out there. That means evaluate if Demetrius Haley was criminally responsible for everybody else out there, so along with Justice Smith. And if they were criminally responsible for each other, then they can be found guilty of second-degree murder. So the question is, and the question has been all along, did they see what happened and not intervene? One way we need criminal responsibility, not intervening. Did they assist And what was happening? Another way we meet criminals are through. And I submit to you that they were doing both. So the good thing about going third, the good thing about the more experienced prosecutors handling the majority of the case is that I've been able to sit and listen and try to find the answer to that question that matters. The answer to that mystery question: did they see it? Did they hear it? Did they know what was happening and not intervene? I've been able to sit and listen to the proof, the audio. I've been able to sit and watch the video. And so I want to talk to you, because it's helped me talk to you a lot about their acts, what they were doing that showed they could see what was happening, where their eyes were, how they were responding after the fact. Mind you, Tadarius Bean, Justin Smith, they didn't go dump water on their face. They weren't coughing like Kemp Hill. But that's just the things that they were doing. What about the things they said? What about the things that they said? Let's take a look at it. And as we take a look at all the things they said, I want to remind you of this language in the criminal responsibility instructions. The encouragement of the principal offender is enough. Let's start with Demetrius Haley. Mr. Leffler talked about how Demetrius Haley fell back at Ross and Raines when majority of the kicks and majority of the punches were happening to Tyre Nichols. Sure, he was. But the problem is, by the time he got to Ross and Castlegate, Emmett Martin had already kicked Tyre Nichols for the last time, and he was done kicking. Go back and watch the video. Emmett Martin was done with the soccer ball kicks. But because Demetrius Haley runs in and says, beat that man's ass, what they want you to believe is the same type of verbal judo, or whatever it's called, that he was using on the first scene. He's not responsible for his kick, and he's not responsible for Emmett Martin's kick when he was done kicking. That reasonable? Is that reasonable? The problem, Mr. Leffler, is that on the first scene, when Haley was using that verbal judo, nobody blew Tyre Nichols' ass off. On that first scene, when he was using verbal judo, nobody broke Tyre Nichols' shit. But here, Ralston Castlegate, when he jumps out that car, when those men are already over Tyre Nichols and says, beat that man's ass, he kicks him himself. He not just kicked him, he looks for the spot where he wants to kick him. And I know the defense wants you to believe he kicked him in the shoulder, but you watch the video. You tell me if it was the shoulder or he kicked him higher up in his face and neck area. But it's not about Haley's kick alone. Because once he kicks him, guess who starts back kicking him? Emmett Martin. And we know Emmett Martin's been kicking him in the face and head all night. So Haley is responsible not just for his kick, but for that kick by Martin. And even if he wasn't kicking him, Haley wasn't kicking him in the head, did you hear him tell Emmett Martin to stop? Did you hear him say, hey, don't do that? Did you hear Haley try to intervene in any type of way? You did. What about Tadarius Bean? Mr. Perry told you, and I would agree, the state agrees. Tadarius Bean is a man of few words, doesn't say a lot. You will watch those videos, you will see a lot of other officers are saying a lot more. Tadarius Bean hardly says anything out there on the scene. But the the one thing that he does say lets you know he saw what was going on. He was aware of what was going on. Emmett Martin is talking about those haymakers he was giving Tyre Nichols. Talking about how he was rocking Tyre Nichols. And what does Tadarius Bean say? He was eating them hoes. Talking about the licks. Desmond Mills told us that. He was talking about the licks that Emmett Martin was throwing and that Tyre Nichols was eating or taking. Let's play this video. I'll play it one more time.
Come on, man. I'm working on though. You rock that machine out there. You eat it, you know what? Come on, man. I'm working on though. You rock that machine out there. You eat it, you know what?
He was eating them hoes. Talking about the licks Emmett Martin was throwing, that the licks that Tyre Nichols was taking. And even in that clip, you see him wide-eyed, it's like he is in the courtroom. Not closing his eyes, not wiping his eyes, not nothing. They're showing that he's affected by the pepper spray that he says was blinding. Nothing. What about Justin Smith? Well, unlike Tadarius Bean, Justin Smith had a whole lot to say that night. He had a whole lot to say that showed he wasn't experiencing tunnel vision. He could hear, he could see what was happening. Mills' body worn camera. Twice you're gonna see and you're gonna hear, more importantly, Justin Smith say hit him. The first time he says hit him, he's talking to Mills. He's telling Mills.
Yeah, she clocking the shit out they teeth. I ain't lying. She clocking it. He say, look, hold on, we got break, foul, Your Honor, foul, flag on the play. Because she up here eating down, okay? She eating. Oh! No, we said, Paul ain't got the voice to do what she doing either. She's selling it. Give me a break.
Justin Smith is saying hit him. first time he says hit him, he's talking to Mills. Mills has taken that baton out. Tyre Nichols, because you can hear it on the ground, is trying to get up off the ground. So when Tyre Nichols does get off the ground, because they made a big point this week and last week about how Tyre Nichols was not responding to the spray. Tyre Nichols was not responding to the baton strike. You're going to see on that video, Tyre Nichols responded to the first baton strike. He was trying to get up and run. I've been kicked twice now, hit with the baton. I'm trying to get up. As he gets up, Bean having one arm, Smith having one arm. Smith says, hit him again. And this time, you're going to see Andy Martin hit him right after. He's talking to Andy Martin.
You got to do that motherfucker ass. I'm gonna try the fuck out. Get the fuck in there. Watch out. Watch out. Get the head. Get the head. Get the head. Watch it down. Watch it. Get the fuck in here.
And so as these hits by Emmett Martin are going on, after Justice Smith said hit him the second time, what do we see? The direction that all these men are looking. Nobody's looking down. Nobody's looking off. You see Emmett Martin to the far right. You see Tadarius Bean with the hook, with the Scully. You see Justin Smith with the shoes. Tyre Nichols looking forward, leaning forward from those hits. Tadarius Bean, Justin Smith, all looking in the same direction. They were hearing those hits. They were seeing those hits. Same eyes. But they want you to believe that Tadarius Bean and Justin Smith are looking down the entire time. But it's Tadarius Bean looking up Mills' body worn camera. Not affected by pepper spray. Not blind. Seeing those licks. Hearing those licks. What else did Justin Smith say that night? I hit that man with so many pieces. Bean was rocking. I jumped in and started rocking. And after this is over, we're not done, but after this was over, those fist bumps, that encouragement that Miss Haley said these guys were giving each other, you the real MVP. You press play, Miss Haley.
Hey, you good, bro?
You the real MVP. Now this one, we took turns giving him pieces. The words of Justin Smith, we took turns giving him pieces. But wait a minute. Why would Justin Smith be saying we took turns giving him pieces? It was only Emmett Martin who was punching Tyre Nichols. But that's because Justin Smith, it's going to take some paying attention to. Justin Smith was actually the first one who threw a punch at Tyre Nichols. Before Emmett Martin landed those haymakers, Justin Smith was the first one who threw a punch at Tyre Nichols. It wasn't a haymaker, but a baby haymaker, if you will. He was the first one. Then with Tyrese's hand, watch their hand right there. And Mr. Perry had it on his diagram yesterday. I don't know if anybody caught it. When he was laying out the strikes and the force used on Tyre Nichols, there was a little yellow line that represented Justin Smith, and he had a hand right there because Justin Smith was the first one who threw a punch at Tyre Nichols. And after that, you see all the big haymakers by Emmett Martin. But this last scene, it's going to take you to take that jury laptop, and it's going to take you to plug those speakers up to that jury laptop, and it's going to take you to listen closely. Because this audio was captured on their body cam. And it was captured after Emmett Martin was going around telling everybody to take their body cameras off. Some of those body cameras on the cars, squad cars, Justin Smith's body cam in his police squad car. So you weren't supposed to hear this. But if you listen, Justin Smith says, I seen Martin, wop, 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 and I said, just fall. Now we're going to come back and talk about this when you all finish listening. And stay right there, please, Miss Haley. That squeaky voice that we heard, that squeaky voice that Neil said Justin Smith has, says, Martin got up and said, wait a minute. Wop, 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 as he's describing the hits by Emmett Martin. And then what did he say? I said, please fall. Who does he want to fall? Tyre Nichols, because he sees him being hit. He hears the wop, wop, wop. Then he goes on to say, it sounded like thud, thud, thud. The licks. He can hear what's going on. But afterwards, there was something else that was said. It's critical to this case. And when you back there in the jury room with better acoustics and you hook that speaker up, you're going to hear Emmett Martin talk about those licks. I thought he was going to fall. But that man who took the witness stand for the state, as Mr. Martin likes to say, Desmond Mills, you're going to hear him say, I said, we about to kill this man. So why would Mills, who hasn't thrown a punch, who hasn't kicked a kick, why would he say, we about to kill this man? After all the deadly force used against Tyre Nichols, this police officer, who understands or should understand criminal responsibility, he doesn't say Emmett Martin is about to kill this man. He doesn't say Haley is about to kill this man. He doesn't say Justin Smith, we're all out here together. We're all in this together. We about to kill this man. Play it one more time, Miss Haley. It doesn't take monsters to kill a man. It doesn't take monsters to kill a man. All it takes is 2 soccer ball kicks to the head 3 baton strikes, 5 haymakers to the head, 2 more kicks, and nobody's saying stop. Nobody's saying don't do it. Nobody's saying grab Emmy Martin. Because that's the question. If they seen it and it was excessive, which every expert who took the stand said every one of those punches and every one of those kicks were excessive force. One said not justified. If they seen it, that's what it takes. Not one person saying stop. Not one person saying grab Emmy Martin. So when the smoke clears and when the mirrors break, those facts and that law that you have, it stands. It's still in place. When we were back in Chattanooga, I went last then, and I stood up, and I said, you all had one job to do when you got here to Memphis. You all had one job to do when you got to this dangerous city. You all got one job while you're here, and that's to follow the facts in the law. To follow the facts in the law. Those are the facts. You have the law. And if you follow the facts in the law, your mind can rest easy, beyond a reasonable doubt. Enough to let the mind rest easy. If you follow the facts in the law, your mind can rest easy that there sits 3 men who are criminally responsible for the murder, the aggravated kidnapping, and the aggravated assault of Tyre Nichols, as well as official misconduct and official oppression. Find them all guilty as charged of every charge. Thank you.
Can we get a round of applause in the chat? Can we get a round of applause in the chat, please? Clap it up for our girl. Okay. One thing I love is an attorney that talk like me. Okay. Very, very inspirational. And our girl is a prosecutor. Okay. We don't come across too many prosecutors of our color that we absolutely love. But this makes number 2 on our list because we do love Miss Agho down there in Mississippi. And maybe they just born and bred in the South. Okay, maybe they born and bred in the South because Miss Agho down there in Mississippi, she did her thing too. She did her thing too. So, I'm pretty sure that the jury is about to, man, and she pretty too, D-Wood. I'm pretty sure the jury is about to get their instructions. And once they get their instructions, they'll go back to do their deliberations. Sorry, y'all gotta send this thing off because they will not stop. They won't stop. They just gonna keep going. We're just gonna. They don't want to stop. They just want to keep going. Hmm. Okay, yeah, them boys is they was panicking. Did y'all see them? Oh man, they were in a full-blown panic. All right, y'all, let's see. Justin was looking very nervous. He absolutely was looking nervous. All of them should have been nervous because she said what we all been thinking. And I love how she got there and said, you hear me? It don't take days to kill a person. It don't take a lot. It took what y'all did to unalive him. Yeah. Yeah. So we just patiently waiting on that, y'all. And then we also got the jury is still deliberating in the Christopher Scher trial. So we are still on verdict watch for that. I don't know what's happening over there in Karen Reed. I ain't really paid attention to Karen Reed today. Look like they on lunch break for another 15 minutes. But oh, wait a minute. Somebody hit the stand and they were talking about who is this on the stand? Let me see who this is. Oh, wait a minute, y'all. Let me see who was that on the stand because he was going through text messages. Y'all know I love a good text message conversation. It was the recall witness. So this was the man who went through the text messages between who was that? Karen Reed and John O'Keefe. He back on the stand. They recalled him.
At this time, we'll call you back in momentarily.
Jury may be excused.
All right, y'all. We're gonna cut on over to Karen Reed. But we got the weatherman was up there, and what I hope they got out of the weatherman is that it wasn't enough snow out there for them folks to say that they ain't see no damn body. But we're gonna go ahead and get the we're gonna watch from here. See what he talking about.
I do.
Good afternoon.
Good afternoon, Your Honor.
Again, if you need to stand it in.
Thank you.
I'm sorry. May I proceed?
Yes.
Good afternoon.
Good afternoon, sir.
Last time you appeared, there were a number of extraction reports that we introduced into evidence. Do you remember that?
Yes, I do.
And just remind us briefly what an extraction report is.
It's the information from the cell phones that I pull up via cell bar.
All right, so I'm just going to ask that this witness identify himself.
My apologies, Your Honor. Could you please again introduce yourself to the jury? Spell your last name for the record.
I'm Trooper Nichols Guarino, Guarino.
You would explain what an extraction report is.
Yes, it's the information in the cell phones. We can create PDFs or portable cases from information, whatever is specified.
An extraction report, can it be general or more narrow?
Yes, it can be.
I want to introduce a few more extraction reports that we didn't get to last time.
Okay.
In this case, did you use Mr. O'Keefe's phone to create an extraction report that included all of his calls from the 28th and the 29th of January 2022?
Yes, I did.
May I approach, Your Honor?
Yes.
And your document, do you recognize that document?
Yes, I do.
And what is it?
It's John O'Keefe's call logs from everyone from the 29th to the 28th. Right.
I move this into evidence, ma'am.
No objection, Your Honor.
Thank you. 65.
Did you create an extraction report that included a text message between the defendant and Jennifer McCabe?
Yes, I did.
May I approach, Your Honor?
Yes.
And in your document, do you recognize that?
Yes, I do.
Can you tell us what that is?
Yes, it's the text chain from the defendant to Jen McCabe.
I move this to evidence, please.
No objection, Your Honor.
Thank you.
Exhibit 66.
One moment. Thank you. With the court's permission, could Mr. Guarino read this to the jury?
Okay.
Could you kindly read that and explain it to the jury?
With all the information on it.
Yes.
This is from the defendant to Jen McCabe, 7:26:52 a.m. on the 29th. It says, can you send me Kerry's number?
Thank you. Did you further create an extract?
No problem.
Yes.
Says defendant's voicemails and on 1/29/2022. The USB thumb drive that should have those files on.
Your Honor, I move this binder as the next exhibit to include both the PowerPoint presentation as well as a clip of the phone calls.
No objection, Your Honor.
Yes. Do you need the thumb drives?
I don't.
Okay.
Mark this, please.
Exhibit 68.
Thank you.
Thank you.
With the court's permission, I would ask that Trooper Guarino take us through the PowerPoint presentation.
Yes.
Is
Thank you.
it okay to begin? Okay.
Please.
So these are the phone calls on the 29th. So at 12:35 a.m., the defendant calls John. That phone call is not answered. 12:34:09 a.m., the defendant calls John. It's not answered. 12:34:38 a.m., the defendant calls John. It's not answered. 12:35:09 a.m., the defendant calls John. Not answered. 12:35:35, the defendant calls John. It's not answered. 12:36:09 a.m., the defendant calls John. It's not answered.
Trooper Guarino, let me stop you there for a second.
Mhm.
Did you look into any internet connection between the defendant's phone and the router and the internet connection at Meadows Ave, John O'Keefe's home that night?
Yes, 12:36:39 a.m., the defendant's phone auto connects to the Wi-Fi PatsFam 123.
Are you familiar with the router at Mr. O'Keefe's home?
I have not done a look at it in person, but that's the known network that's listed under it. There's two, PatsFam 123 and O'Keefe 74.
Did you learn the range that a connection must be in order to connect to his router?
Yes, so depending on the router, it's either a 2.4 gigahertz or 5 gigahertz radio band or signal band, I should say. Depending on which one it's connecting to, which band, it's either 150-foot indoor range or up to 300 feet outdoor. So again, when you pull into your home, sometimes you can still be connected to your home Wi-Fi in the driveway.
And again, can you give us the time of the connection between the defendant's phone and Mr. O'Keefe's router at Meadows Ave that night?
Yes, 12:36:39 a.m.
Please continue.
At 12:36:40 a.m., the defendant calls John. It's not answered. At 12:37:08 a.m., the defendant calls John, and voicemail number 1 is left with voice.
Ms. Gilman, would you kindly play the voicemail for 12:37:08?
At 12:38:26 a.m., the defendant calls John. It's not answered. 12:39:03 a.m., the defendant calls John. It's not answered. 12:39:37 a.m., the defendant calls John. It's not answered. 12:43 a.m., the defendant calls John. It's not answered. At 12:41:35 a.m., the defendant calls John. Voicemail number 2 is left. Some beeping noises, appears to be a butt dial or accidental call.
Ms. Gilman, could you play the voice message at 12:41:35?
The defendant then texts John O'Keefe at 12:55:31 a.m. on the 29th, "I'm going home." The defendant texts John O'Keefe, sorry, "See you later" at 12:55:50 a.m. on the 29th. At 12:58:19 a.m., the defendant calls John. It's not answered. 12:58:47 a.m., the defendant calls John. It's not answered. 12:59:24 a.m., the defendant calls John. Voicemail number 3 is left with voice.
Ms. Gilman.
John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
At 1 a.m. and 26 seconds, the defendant calls John. It's not answered. At 1 a.m. 49 seconds, the defendant calls John. Voicemail number 4 is left. It's 1 second called, no sound.
Ms. Gilman.
That was it. The defendant texts John O'Keefe, "Your kids are cucking alone," at 1:02 a.m. on the 29th. Defendant texts John O'Keefe, "I'm back in Mansfield. The kids are home alone," 1:04:14 a.m. on the 29th. At 1:10:17 a.m., the defendant calls John. Voicemail number 5 is left with voice.
Ms. Gilman.
Yeah, it's 1 in the morning, I'm with your fucking niece and nephew, you fucking pervert. You're a fucking pervert!
At 1:10:44 a.m., the defendant calls John. It's not answered. At 1:12:18 a.m., the defendant calls John. It's not answered. 1:12:46 a.m., the defendant calls John. It's not answered. 1:13:13 a.m., the defendant calls John. Not answered. Sorry. At 1:14:11 a.m., the defendant calls John. It's not answered. 1:14:44 a.m., the defendant calls John. Not answered. 1:16:10 a.m., the defendant calls John. Not answered. 1:16:38 a.m., the defendant calls John. Not answered. At 1:17:37 a.m., the defendant calls John. So when voicemail 6 is left with voice.
Ms. Gilman.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself.
At 1:18:38 a.m., the defendant calls John. Not answered. At 4:38:14 a.m., the defendant calls John. Not answered. 4:38:49 a.m., the defendant calls John. Not answered. 4:39:39 a.m., the defendant calls John. Not answered. 4:40:05 a.m., the defendant calls John. Not answered. 4:42:05 a.m., the defendant calls John. Not answered. 4:42:54 a.m., the defendant calls John. Not answered. 4:45:10 a.m., the defendant calls John. Not answered. 5:04:27 a.m., the defendant calls John. Not answered. 5:21:28 a.m., the defendant calls John. Not answered. 5:21:58 a.m., the defendant calls John. Not answered. 5:23:26 a.m., the defendant calls John. Voicemail number 7 is left with voice.
Ms. Gilman.
At 5:24:27 a.m., the defendant calls John. Not answered. 5:25:28 a.m., the defendant calls John. Not answered. 5:26:14 a.m., the defendant calls John. Not answered. 5:28:16 a.m., the defendant calls John. Not answered. 5:28:43 a.m., the defendant calls John. Not answered. 5:29:21 a.m., the defendant calls John. Not answered. 5:29:46 a.m., the defendant calls John. Not answered. 5:30:15 a.m., the defendant calls John. Not answered. 5:30:52 a.m., the defendant calls John. Not answered. 5:31:21 a.m., the defendant calls John. Not answered. 5:36:29 a.m., the defendant calls John. Not answered. 6:03:02 a.m., the defendant calls John, and voicemail number 8 is left with some voice and noise and background.
Ms. Gilman, could you play that, please?
Yes, I need someone to take over for you. 34 beautiful, Vietnam, your lady and top no. Where's the blankets? I don't see blankets, Harry. If I need I know, Mom, I know the answer. I know.
We have the lights on, please. I have no further questions.
All right. Mr. Alessi, does this seem like a good time to take the luncheon recess?
No, Your Honor.
Okay. All right, so folks, we will take a 45-minute luncheon recess.
Court, all right, please. Jurors, close your notebooks and follow me.
Goodbye. The meeting as an attendee and will be muted throughout the meeting.
Back in session, you may be seated.
The host would like you to unmute your microphone. You are unmuted.
All right, Mr. Alessi, you all set?
Thank you, Your Honor. No questions for the witness.
All right, you are all set. You know.
Thank you.
Do you have another witness?
I do.
Okay.
I have some other matters I'd like to introduce before
Sure.
that. I may? May I, Your Honor?
Yes.
I'd like to introduce clip 1 and play it for the jury.
I mean, I didn't think I hit him, but could I clipped him? Could I tapped him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold, did he come to again?
In this case, you dropped him off at the party.
Yeah, would have had to.
Your Honor, I have keeper record certificates I'd like to mark for identification. May I approach?
Yes. Thank you.
There's a series of them, Your Honor. Sure. And these are all for identification. For identification. Next, I'd like to introduce as an exhibit the text messages that I read with Mrs. McCabe during the testimony.
Yeah, just a moment.
I'd move this into evidence, please.
No objection, Your Honor.
Thank you.
Your Honor, may I call the Commonwealth's next witness?
Please.
Commonwealth calls Charles Ray.
All right. So thank you, Jagger. You got to build your algorithm, okay? You got to get your algorithm up.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Sir, could you please introduce yourself to the jury?
Yes, good afternoon. My name is Charles Ray. I'm a lieutenant with the Canton Police, last name R-A-E.
How long have you worked for the Canton Police Department?
Approximately 25 years.
And when were you assigned lieutenant?
Approximately 10 years ago.
I want to go back to January 29th, 2022. Do you remember that morning?
Yes.
Were you working that morning?
Yes, I came in for the day shift.
When you first came in for the day shift, did you have any particular duties or responsibilities?
I would have been a patrol shift commander for the 7:45 a.m. to 3:45 p.m. Incoming shift.
Had you learned about an event that occurred at 34 Fairview Road?
I had.
Were you part of that response or group of officers that went to 34 Fairview Road?
No, I was not.
Your role that morning was unrelated to 34 Fairview Road?
Correct.
At some point, did you learn the name of the person who was at 34 Fairview Road that needed medical attention?
I did.
And what was that person's name?
Mr. John O'Keefe.
Did you learn that Mr. O'Keefe was brought to the hospital?
I did.
At some point, were you advised of his status?
At some point later in the day, yes.
While you were at the station after learning about Mr. O'Keefe,
You are muted.
did you make a decision to do something?
I did.
Was it an order from somebody or did you make a decision on your own?
I can't recall whether it was an order from somebody. I don't think it was an order, but it probably might have been at the suggestion of the former chief of police. Either that or it just developed organically. But one way or the other, we decided that the right thing to do would be to do a well-being check of the home at 1 Meadows Ave, which is the decedent's residence.
Why were you doing a well-being check at Meadows Ave?
We at that time, we were under the impression that there may be 2 unattended young children at the home.
When you decided to go to Meadows Ave, did you use a police vehicle?
Yes.
Do you remember which vehicle it was?
It was Canton 682, which is the supervisor's vehicle.
When you decided to go to Meadows for a well-being check, did you ask anybody to come with you?
Yes, myself and Sergeant Lehan.
Do you remember the weather that morning?
Yes.
Could you describe it for us?
There was a well-forecasted snowstorm that had already began, and it was starting to pick up intensity at that point.
At this point, I had moved to admit the dash cam video from Cruiser 682.
Okay,
No objection.
thank you.
Did you travel from the police station to Meadows?
Yes,
Do you remember about how long that took you?
a few minutes.
Who was driving?
Sergeant Lehan was driving.
And where were you seated?
I was in the passenger seat.
Do you remember arriving at Meadows?
Yes.
With the court's permission, I would show a portion of Cruiser 682.
Okay.
Could you stop, please, Ms. Gilman? I note that the time is 8:23:10. Do you remember the time when you got there?
I didn't make note of it mentally at that time, but I've since learned that, yes.
Is this video that you have just watched consistent with your memory that morning?
Yes.
The cruiser cam is showing two vehicles in the driveway. When you arrived that morning, did you know whose vehicles they were?
At that time, no.
At that time, did you pay any particular attention to either of those vehicles?
No.
If I could show Exhibit 10, please. So does that appear to be a still photo from the video we just watched?
Yes.
And could I have Exhibit 11, please? When you arrived for the wellness check that morning, were you working as an investigator in any way?
No, I was not.
Did you happen to pay any particular attention to the right side of the back of that car that morning?
No, I did not.
And is that photograph a close-up of the previous picture?
Yes.
Does it appear to be a still photo taken from the video on the cruiser that you were driving that morning or that you were in that morning?
Yes.
Okay, you can take that down, please. Thank you. After you arrived at Meadows, did you do anything?
When we arrived at Meadows, we walked up to one of the front doors and rang the doorbell, knocked on the door. Anywhere we could see through plain view, we were just trying to see if we could raise anybody, see if the children were at the house.
Did you find anybody?
We did not.
I'm going to ask to show 159. It's a portion of an exhibit that's already been introduced.
Okay.
Thank you. At this time, I'd move to introduce former 19.
No objection, Your Honor.
Okay.
Exhibit 72.
Thank you. The first video well, the second to last video you just saw, is that you and your partner arriving?
Correct.
In the last video, who's in the doorway?
I was on the right side of the frame and Sergeant Lehan was on the left side of the frame.
How long did you spend at the residence for the wellness check?
A few minutes. I don't think more than 5 minutes.
Thank you. I have no further questions for the witness.
Right, any questions, Mr. Yanez?
We have no questions, Your Honor. Thank you.
All right, so you are all set. Thank you. So your next witness, Mr. Brennan.
My next witness would be Kevin O'Hara.
You solemnly swear the evidence given to the court and jury in the case now and guarantee the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Brennan.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
My name is Kevin O'Hara, O'Hara.
Where do you work?
I'm a lieutenant with the Massachusetts State Police,
How long have you worked for the Massachusetts State Police?
23 years.
When you began your career, what was your role with the Massachusetts State Police?
I was assigned as a trooper, a patrol trooper, working out of several barracks across the state.
Did you have to have any special education or training before you became an official Massachusetts State Police trooper?
Yes, I did. We went to a 6-month academy in New Braintree.
How long were you on patrol for?
I was on patrol for 17 years until I became a sergeant in 2018. So 16 years, became a sergeant, then a lieutenant.
In those 16 years, did you have any additional training after basic academy?
Yes, continued training throughout the years, additional training. Eventually, I wound up joining a search and rescue team, went to search and rescue training.
Tell us a little bit about search and rescue, what you did and what you do.
I'm the team commander for the State Police Special Emergency Response Team, which is known as CERT. I'm also the search and rescue coordinator for the state of Massachusetts. As a team, we conduct monthly trainings, at least twice a month, where our team will come together and train. We've been to trainings all across the country to hit national training standards.
Do you have any particular roles when you look for certain types of things?
So for CERT, we have 3 main mission types. We will do lost missing person searches, we will do evidence searches, and then we also do crowd control or security at large scale events such as the Boston Marathon, the July 4th celebration. We get assigned to Gillette Stadium for all the events down there as well.
You mentioned that you work part of your work is looking for missing persons.
Yes, sir.
Did you receive any specialized training, have any special experience looking for missing persons as far as training technique?
Yes, we get certifications through NASAR, which is a National Search and Rescue Organization, NUSAR, which is a New England-based search and rescue group. We will train several different types of trainings to, improve our search techniques, including man tracking, probability of detection, critical separation, which is how we'll line up as we're searching certain areas. We've also gone, as I stated before, to national trainings where we've now really used a lot of statistical-based searching in our searches. We'll use live tracking maps now, so we've really advanced the way we search for missing persons.
When you're searching for a missing person, is there a routine or does it depend case by case?
We'll start off with a set normal way we'll deploy. More than likely, we'll start with a canine, searching high probability of areas, trying to get people out as quick as possible. And then eventually it may turn into a line search or a grid search.
You said that you lead the CERT team?
That's correct, sir.
How many CERT teams are there with the Massachusetts State Police?
Just one.
How do you decide what different cases or situations to get involved in? Is that your request?
It's not at our request. We'll receive requests either internally through other members of our department or externally from outside agencies.
So can you take us through very basically how would a typical request come to you?
Most of the time I'll receive what I call a courtesy notification. I'll get a call from someone that I know in the department or a local police department asking, giving the particulars of the case and if we'd be available and what I think about our response. If we are available, if we're not already on another mission, we'll then start the approval request process, which I have to send up through my chain of command. I have to send that up through a captain, which then will go to a major who's in charge of the special operations. And then he may have the final say. It may even go higher to him to Lieutenant Colonel of Field Services. If the request is internal through another member of our department, it also has to go up their specific chain of command as well. Sometimes getting an external request sometimes goes faster because there's not that second chain of command, to go through.
In 2022, how many full-time members were on the CERT team?
At that time, we had 55 members, which were, excuse me, sir. We had one full-time member, 55 total members on the team.
So the members on the CERT team, did they engage in other roles with the state police at the same time they're a member of the CERT team?
Yes, it's an additional duty. They have a primary assignment either at a barracks or some other assignment throughout the state.
If you decided on accepting a mission or you were assigned a mission, who determines how many people from the CERT team would attend?
That would be determined by myself and the captain from Special Operations.
You mentioned back in 2022, there was one full-time member and 55 part-time members of the CERT team?
Yes, 55 total, correct, sir.
As we stand today, how many full-time members of the CERT team?
Currently, we're 69. We did have 71. We've had a few members leave the team recently.
Are those full-time or part-time members?
I'm sorry, that's full total members. We have currently 5 full-time members. So we increased on both ends.
Are members of the CERT team who work for the Massachusetts State Police drawn from different geographical locations around the state?
That's correct. We try to split east-west the best we can geographically, just so we have as quick a response time as possible. We'll break it down further into the northeast part of the state, the southeast, central, west, but main breakdown for us is east-west, basically using 495 as our boundary.
If the CERT team's assigned a mission and there are members that have chosen to participate, how often would you go to that scene or involve yourself in that particular event?
When I was the only full-time member, probably 99% of the missions I would go to. Now we have a few other supervisors on the team. I have a full-time executive officer who's also a lieutenant, but my role hasn't changed too much, still 90 to 95% of the missions.
I want you to take us back to January 29, 2022. Were you contacted or was a request made for you to consider and accept the mission?
Yes, I received a call from Lieutenant Tully.
After receiving the call, what was your process?
Again, that was what I would classify as a courtesy notification to see if we were available, if he thought we could get a response on that date. I told him we would be able to respond. I asked him if he had started the approval, the request for approval up his chain of command, which he hadn't at that time. He stated he would start on that, and then I contacted my captain after getting off the phone with him to start the approval process through my chain of command.
Do you remember generally about what time this process began?
He called me at 2:32 p.m.
At some point, was the task or the mission assigned?
So I told Lieutenant Tully that, we had received a snow that day. I told him most of the members, including myself, may not have shoveled out their driveway. I told them at best case scenario would be an hour plus response time, depending on how long, it would take people to shovel out their driveway. So at 2:53, I contacted one of the West team members, a sergeant from the West team, to have him send out an alert to our full team just to build an availability list to see who was available. So at 2:53, that got sent out to the entire team.
At some point, were you able to acquire or compile a team?
Yes, Sergeant Simpson was able to put that list together.
And what time did you start to begin your way towards Fairview Road?
At 3:48, we sent out an alert for the activation of our team, including notifying the team which members would actually be responding. I had just finished shoveling my driveway. By the time I changed into my uniform, got all my equipment together, I left my house at 4:13 p.m.
When you left your house, were you in an assigned cruiser or a personal vehicle?
Assigned cruiser, sir.
Is there tracking of assigned cruisers?
Yes, there is.
Could you share with us how that works?
So each cruiser has a automated vehicle locator or GPS system. It tracks everywhere you go, marking every time you stop.
And did the vehicle you were driving have that system?
Yes, it did, sir.
Before you left to head towards Fairview at 4:13 p.m., had you already defined what the mission was going to be?
Yes, I knew we'd be conducting an evidence search.
Did you have any idea of how you were going to do that?
Yes, I spoke to Lieutenant Tully just to get an idea of the area we'd be searching. I determined how many members we would need to respond to that search, which at that time I figured we would need 8 members to respond. Normally, as the team leader, I'll function more of an incident command role behind the team, documenting some of our efforts. So we dispatched 8 members to the scene. Unfortunately, due to the snow, one of my members was not able to respond. So we only had 7 members officially arrive on scene, including myself, which changed the dynamics a little bit of our search, but nothing major.
How did it change the dynamics of your search?
Well, like I stated, normally I would stay behind the line of searchers, documenting what they do, more of as a command role. But because we were one member short, I wound up participating in the search, more hands-on than maybe normal.
Did you ultimately actively participate in the search firsthand?
Yes, I did, sir.
Tell us about when you first arrive at 34 Fairview and you get out of your cruiser. What's the weather like at that point?
Still snowing.
What's the temperature like?
Very cold.
Visibility?
It was windy, but no real issues for us to see as we were working.
Was there a particular area you were looking at?
Yes, once I spoke to Lieutenant Tully, we wound up focusing on a specific area to search.
What time did you arrive at 34 Fairview?
4:56 p.m.
Did any of your team arrive before you?
Just prior to my arrival, one member arrived at 4:54 p.m.
And do you remember who that was?
It was Trooper Jason Bousselet.
Were there other members that arrived after you?
Yes, there were.
Did you wait until the entire team was there before you began?
No, we did not.
The other members that arrived, do you remember who they were?
Yes, I do, sir.
Do you happen to remember when they arrived?
Yes, I do, sir.
Could you share that with us?
Trooper Blake Bearden arrived at 5:21 p.m. Sergeant Charles Luis arrived at 5:24 p.m. Sergeant Michael O'Brien arrived at 5:24 p.m. Trooper Scott Viscardi arrived at 5:34 p.m. and Sergeant Anthony Carrier arrived at 5:41 p.m.
When you first arrived at Fairview and you looked at the scene, did you have any personal knowledge where any person had been in that area?
No, I did not.
Did you learn generally that a man was found in that area?
Yes, I did.
Did you have any photographs or precise location of exactly where that person had been found?
No, we did not.
Did you have a general area that you were directed to?
Yes, sir.
Any landmarks you can share with us in the general area where you were going to be focused on?
There was a flagpole in front of the residence. There was also a fire hydrant in front of the residence.
Who made the determination of the scope of the area that you would search?
I made the final markings of the distance we wanted to search, but we were guided by Lieutenant Tully's information he was able to provide for me.
How did you decide the depth and the broadness of the area you were going to search?
He informed me that there was a vehicle involved in the incident. He told me where that vehicle had been parked. So we wanted to make sure we started prior to where that vehicle was parked, which was almost adjacent to the front door of the house. If you were to look at the house we were at 34 Fairview Road, you don't say there was two front doors, a main front door and then a secondary front door at, closer to the garage, whether that's a mudroom or a den. So he'd stated the vehicle was parked almost directly across from the main front door, which again, looking at the house, that's on the left front door. So we marked off that as our starting location and we wanted to search down to the fire hydrant.
Were you looking randomly or was there any specific items you may have been looking for?
No, we were instructed that it was believed that the vehicle may have had a broken taillight. So we were looking for taillight pieces. We also were informed the victim in this incident was missing his shoe. So we're going to be looking for his sneaker as well.
What tools did you and your team bring to begin the search?
We brought shovels. We also brought push broom. I brought a couple of garden rakes. And we also were all equipped with headlamps, hiking lamps that you would wear.
Were the headlamps the only lighting you had for the search?
Once we began the search, we wound up turning a few of the cruisers around just to put some extra headlights on the scene.
Were the cruisers parked so they were facing the yard?
They were parked on the street, just covering the street, sir, not angled towards the yard at all.
I want to ask you some questions about the tools you brought. You said you had shovels, some garden rakes, and brooms.
Yes, sir.
What was the purpose of the brooms?
Just to help us sift through the snow very carefully. We wanted to be slow and methodical as we went through the area.
How about the shovels? Were you concerned that if you used the shovel, you could hit an item and break it?
Yes, but we went as slow as we could, layer by layer, as we moved down throughout the snow.
When you use shovels, were you digging like you would dig vegetables in a garden?
No, sir.
Could you explain a little bit about the process before we get into the actual search of how you as a team would look through snow? Would you just pick it up and turn it over, or was there a process in place?
No, eventually we wound up going again. Our searches, we'll call it a grid search, but it's a line search where we're all lined up. Again, talking about critical spacing. If we're searching for a particular item on a search, we may use a replica item to say, okay, how far can each member be away from each other? Because this was such a small search area, our members lined up almost shoulder to shoulder. Once we were on a line, we would slowly move forward, each member taking out snow, sifting, small layers, sifting it out at their own feet with a right flank along the curb in front of the house. That snow would eventually get moved out to the street where I was standing. I was the left flank on our line. I would then re-go through that snow, make sure we didn't miss any items or by accident carry an item that we were looking for over towards the middle of the street. Once I was satisfied there wasn't anything there, I would take that snow and throw it across to the other side of the street.
Before you began the search, did you have a chance to look around at the surroundings, including the street, the berm separating the street from the yard, and the area you're going to look at?
Yes, I did, sir.
Did you see any evidence that there had been any plowing before you arrived?
Yes, the plow had come through the area. The plow had not gone curb to curb, so we had a good 3 to 4 foot embankment coming off each curb. So at that embankment where the snow had come to, there was higher levels of snow before it dropped down to the normal snow depth that the rest of the area had received.
Could you describe a little more simply what you mean that the plow didn't go curb to curb?
So again, the plow had probably only done enough distance for maybe 2 vehicles to safely pass each other, not enough to go all the way to the curb on each side of the street. As we wound up parking, the responding members, as they wound up parking in the snow closer to the curb, and at the end of the night, several of the cruisers were stuck. We had to push them out.
When you looked at the snow that appeared to have been pushed by the plow, did that snow that had been displaced reach the berm, the separation between the street and the yard?
No, there was 3 to 4 feet between the edge from where the plow was to where the curbing in front of the house was located, sir.
The area where you searched or where you were pointed to where Mr. O'Keefe was in that general area, did it look like any snow from any plow had reached that area?
No, it did not.
When you began the searching, do you know what time it was that you actually began searching?
We moved my cruiser and Trooper Boussolet's cruiser at 5:20. We had started.
All right, another day of Lauren, Karen Reed, and their inconsistent trial. So to be honest with y'all, I'm not 100% into Karen Reed. I do like to come in and pop in for the theatrics, but this is kind of boring today. So I got a quick question for y'all. Are y'all watching the stabbing murder? The serial stabber trial? I think I low-key want to switch over to that one and start and see what's going on over there in California. I think they're on day 2 or 3. But let me know what y'all think. Jump down in the comments and let me know what y'all, if y'all have been watching that one. There's another trial that I'm looking for. So I'm saying all this to say we about to get off the camera. But we also got an hour before the YNW Melly stuff comes back on. So jump down in the comments and let me know what y'all watching outside of Karen Reed, because again, we are likely going to swap over to another trial.
Gridding off where we wanted to search, but at 5:20, that's when we moved our cruisers to put the headlights on. That's right. Trooper Bearden and the 2 sergeants arrived quickly after on scene. So by 5:24, we started. All 5 of us were lined up shoveling. When the 2 other members arrived on scene, they just joined in on the line to help us move.
From when you first arrived at 4:56 p.m. to when you began the search at 5:20 p.m., did you see anybody enter the area that you were going to search other than you or a CERT team member?
No, they did not.
Were there other people in the area outside the scene or the grid that you were going to search other than you and members of your CERT team?
Lieutenant Tully arrived on scene.
Was there anybody with Lieutenant Tully?
At one point, he had several other people with him. Maybe, I believe, 5 throughout our search. Maybe 5 different people, including him, were on scene.
Were those people part of state police?
At least 1, maybe 2. Unfortunately, I don't recognize all 2,500 members in our department, but there were probably about 5 total people on scene, sir.
Was there somebody who was picking up any evidence that you may find and putting it in bags and preserving it?
After we found located evidence, it was documented on scene by the detectives.
So you yourself were not documenting?
No, and again, that's maybe a little change in the dynamics. If I had been more of in an instant commander role, I probably would have documented time, location, again, for our internal records. The primary record will always be at the hands of the detectives. But because I was actively searching, the detectives handled all documentation.
Did you see somebody from the state police putting evidence in bags after it was pointed out to you?
Yes, sir, they did.
When you began the search, what part of the street or yard did you begin with?
We started where we were informed the vehicle was parked, which again was by, almost directly across from the front door of the house. And we began working south towards Chapman Street.
During the process of the search, if somebody were to find a piece of evidence, what was the process? What would happen?
He would notify myself and Lieutenant Tully, and we would stop our operation until that was documented by the detectives on scene and collected.
Do you know what time the first piece of evidence was found?
I believe it was 5:45, sir.
Do you remember what the first piece or item that you or the CERT team found was?
It was a piece of taillight.
May I approach, Your Honor?
Yes.
So I'm showing you two photographs. Do you recognize what is in them? First one,
Yes, sir.
what is that?
It is a piece of clear lens from a taillight.
And the second photograph?
It's the same lens, just a little enhanced, closer.
A close-up?
Yes, sir.
I'd move to introduce these two photographs into evidence.
No objection, Your Honor. All right, so one is the close-up of the other.
It is.
So Madam Court Reporter will be the next plus A.
73 and 73A.
Let's briefly see those photographs.
With the court's permission, could I show the exhibits?
Yes.
We see exhibit number 129, please. Oh. Doesn't have it. All right, I'll move on at this point. And that was at 5:45?
Yes, sir.
At 5:50, do you know if another item was found?
I don't know the specific times. I know the first piece was 5:45, but again, I didn't handle the documentation and I have not seen the evidence log.
Okay. Inevitably, did you or your team find an item of clothing?
We found the sneaker. Yes, sir.
A sneaker?
Yes, sir.
Can you describe where the sneaker was found?
Sneaker was flush up against the curb and it was inverted upside down.
Was there anything in the sneaker?
There was snow on and inside the sneaker.
May I approach?
Yes.
Sir, I'm showing you three photographs. Do you recognize the first one?
Yes, sir. That's a photograph of the sneaker we recovered.
And where is it located in reference to the berm?
It's directly up against the curb.
Can you show, take a look at the second photograph, please? What do you see?
It's a close-up picture of the same sneaker we located.
And third photograph, please.
Again, just a close-up, different angle photo of the sneaker we located.
Thank you. All right, I'll move these three photos into evidence, please.
No objection, Madam. Thank you. All right, so Madam Court Reporter 74A.
Hmm. 74, 74A, and 74B so marked.
Thank you.
Thank you. With the court's permission, could I show these photographs?
Yes. Oh my God.
Could we get a more of a close-up, Ms. Gillen? Sir, can you describe what you're seeing here?
That's the sneaker we located up against the curb. You can see the snow in the background, and that's the flagpole in front of the house. You can see it's still snowing at this time.
Could we see 121, please? And sir, can you describe again what that is?
Just a close-up photo of the sneaker we located up against the curb.
Is that curb the black area to the right?
Correct, sir.
How high is that curb?
Not sure, sir. Several inches.
122, please. You described a photograph with a sneaker with snow in it. Is that photograph?
Yes, it is, sir.
Okay, thank you. You can take that down. That night, do you recall if there was any other pieces of taillight recovered?
I believe in total we located maybe 6 or 7 pieces of taillight.
May I approach, Your Honor?
Yes.
Sir, I'm handing you 3 photographs.
Thank you.
You recognize the first photograph?
Yes, I do, sir.
And what's in that photograph?
It's a piece of red taillight that we located.
Could you look at the second photograph, please?
Yes, sir.
What do you see there?
It's the same piece of taillight that we recovered, just a close-up version. You can see the molding of an overturned shovel. That piece of taillight actually came up as one of our team members was shoveling. When he overturned his shovel, the piece of taillight was there, and you can see the actual molding from his shovel.
And the third photograph?
That is another piece of taillight that we located at ground level.
A different piece?
Yes, sir.
Let's stick with photographs 1 and 2. Photographs 1 and 2, a close-up and a further view of a piece of taillight. Are those fair and accurate depictions? Does that piece appear that night?
Yes, they are, sir.
All right, we'll introduce 2 photographs into evidence.
No objection. Thank you. One's a close-up, right?
Yeah, Your Honor.
75A.
So when these items were found, did you examine or study the depth of those items when they were found?
I did not, sir. Gave them a glance when our team members told us we found something. And then Lieutenant Tully took over documentation. I returned to my place, on our line.
Do you know if any of the items were touching the ground or were they on snow?
A couple of the pieces were found at ground level, touching the asphalt.
And you said there was another item found that we just talked about? A separate piece of taillight?
Yes, that photo you showed me was a separate piece of the taillight we located, sir.
May I approach?
Yes.
Showing you 2 photographs, could you look at the first photograph?
Yes, sir.
What do you see?
A piece of taillight at ground level.
And if you could look at the second photograph, what's that?
It's a close-up enhanced view of that same piece of taillight.
So it's just a different view of the same piece of taillight?
Correct, sir.
Is that a fair and accurate depiction as that piece of taillight appeared that night?
Yes, it is, sir.
I would move these 2 into evidence, 1 photograph and a second is a closer-up view.
No objection.
Okay.
Exhibit 76 and 76A.
While you were conducting the search, did anybody but your team, Trooper Tully, the person who was documenting the evidence, did you see any other people who were not law enforcement in the area?
At some point during our search, the media arrived on scene, began filming us or taking photos.
Was there anybody from your department or a different department that was managing the crowd?
No, there were members with Lieutenant Tully that I believe were not state police members, but I wouldn't know how to characterize what their job description was, sir.
At any time, did anybody enter that area or scene, the grid that you and your members were working on, other than your group and Trooper Tully and the people with him?
No, correct. Once we marked off our area, no one came forward of our line. That whole search area was fresh, undisturbed snow as we moved through the area, and no one moved past our line. Even when Lieutenant Tully and the member who works in his unit came to collect the evidence, they didn't move past the point we'd searched up to at that time.
Why were you so careful about anybody coming onto your grid?
We don't want to disturb our scene, but we also don't want to move forward unless we're all moving together, acting in unison.
Given you had brushes and rakes and shovels, did you get through every piece of that area?
We didn't go all the way to where I had marked off originally, because after we'd found everything that was collected, we had gone approximately 8 to 10 feet without finding any other evidence. Lieutenant Tully and I had a discussion. I think we determined we'd found everything we were going to find that evening, and we decided to suspend the search.
Was it a search that took up the whole front yard and street of that area?
Our focus was on the street. We really didn't touch the front yard at all. We started to go over the curb at one point to see if we could search the grass area, but we could not properly definitively say we were searching it well. As we started to move the snow, we couldn't really differentiate down to the grass level.
How hard was the ground?
It was cold, frozen.
The ground was frozen?
Sir.
And so not being able to search the entire yard, was there a plan at that point? Did you just end your mission?
So when we suspended our search, we'll always do a full team debrief, and we'll debrief with the person who requested our search. And at the end of our search, we'll come up with what we call our probability of detection. We'll give a baseline determination of what I think our percentage-wise, whether we would have found what we were looking for. We'll provide that. I did provide that to Lieutenant Tully. Told him there was a good chance we did not locate everything that evening, and we offered to return at a later date or time at his request.
When you were looking generally for pieces of taillight in the sneaker, were you informed, did you have any idea how much taillight would be in that area?
I did not know, sir.
Was there any way for you to, at that point, identify exactly what you were looking for?
No, we didn't have a photo of the taillight. I was never shown anything, so I wasn't sure how much we were actually looking for.
May I approach, Your Honor?
Yes.
I'll withdraw that. What time did you end the search?
Approximately 6:15, I believe. I was the last one to leave, which was 6:23 p.m. when I left.
And so how long was the entire search?
It was about 55 minutes. We started again around 5:20, ending around 6:15, sir.
Do you know if any other colleagues or members went back at a later date?
I've been informed that they did, yes, but not from my team, but other members of our department.
I'll allow it, just move on.
Did your team go back?
We did not, sir, no.
Thank you. I have no further questions.
Good afternoon, Lieutenant.
Good afternoon, sir.
When you first arrived at the scene, was there crime scene tape up?
No, there was not, sir.
Was there any barricade up at all?
No, there was not.
Was there any evidence that the crime scene was being secured at that time?
There was no police presence on scene, sir.
Okay. So that when you arrived, the scene had been left unsecured. Do you know how long it had been left unsecured?
I do not, sir.
So before you arrived, at least, and before your presence was known, for some time before you got there, that scene could have been accessed by anyone, to your knowledge.
Well, I think the weather played a good help in us with the scene security, because with that being fresh, undisturbed snow, and with the man tracking we do, we would be able to determine if anyone had access to that area.
Of course, of course. But you don't have any personal knowledge of anybody actually securing that scene for onlookers, bypassers, anybody that wanted access to it, they could have had it?
Not that I'm aware of, sir.
Okay. You indicated that Lieutenant Tully first contacted you but exactly at 2:32 p.m., correct?
That is correct, sir.
At that time, your team was not stood up. In other words, you were not activated, because that was an initial call by Lieutenant Tully, not an activation call, correct?
Correct. That's a courtesy notification, sir.
And at that time, Lieutenant Tully had not received the proper protocol, the proper approvals through the protocol to actually have your team activate and have your team dispatched.
Yes, I think he'll normally, when we get activated, before they start the process going through their chain of command, they'll call me just to see if we're available and if we could actually respond, instead of wasting other people's time calling us if I were to say, no, we are already assigned on another mission at this time.
Right. So around 2:53, you indicated that one of your subordinates, Sergeant Simpson, notified the rest of the team that get ready, but we have not been given the green light, correct?
Correct, sir. Building an availability list of who could respond.
Okay. That was just a kind of a precursor, if you will, for lack of a better phrase, to make sure that you had the available personnel, so when the green light, or if the green light came, you could activate.
Correct, and to help start giving people the heads up to start shoveling their driveway. Like I said, as soon as I received that call from Lieutenant Tully, I hadn't shoveled my driveway yet. I went out and had to go clear my driveway and my cruiser. And the end of my driveway, we usually get plowed in by our plows. We had several feet of snow at the end of my driveway, sir.
Lucky you.
Yes.
All right. Did Lieutenant Tully inform you in that first phone call that colleagues of his, Massachusetts State Police colleagues of his, were already en route to Dighton to retrieve or seize the SUV?
He did not say that, sir.
Did Lieutenant Tully inform you that Massachusetts State Police had actually contacted the Dighton Police Department for their assistance in potentially seizing that SUV?
He did not tell me that, sir.
Did he indicate to you, you indicated that your conversation was at 12:32. Did he indicate that he had just gotten off the phone with Dighton PD at 12:31, just a minute prior?
Our phone call was at 2:32, sir.
I'm sorry.
I don't know if that can.
Did I say 12:32?
That's a different time you're looking to.
2:32, and he had just gotten off the phone with Dighton PD at 2:31. Did he indicate anything like that?
No, we did not, sir.
Okay. So we do know that at that 2:30-ish hour, you were not authorized to respond to the unit, to the location at that point. None of your units were en route at that point.
No, neither one of us had requested approval through our chain of command at that time, sir.
And you've already told us that you didn't head out until just after 4, sometime after 4 p.m.?
Yes. My GPS data has me leaving my driveway at 4:13 p.m.
Got it. Once you were at 34 Fairview, you arrived first, correct?
No, sir.
I'm sorry, I mistook that. Tell me who did arrive first.
Trooper Busalil arrived at 4:54, and I pulled in just after him at 4:56, sir.
My mistake. When you first arrived, you were waiting others of your team to arrive as well in their personal vehicles or their marked vehicles, correct?
They were still en route at that time, yes, sir.
When you got there, you did not know at that point where you were going to be directed to search, correct?
I did not know, sir.
All you knew was a residence and an address, correct?
Correct.
As your team members arrived, were they arriving in personal vehicles, cruisers, or some combination thereof?
They were all arriving in state-issued cruisers.
Okay, so all 7 of you arrived. There were 7 total, correct?
Correct. We, again, initially started 8. One member was not able to get off the end of their street due to plowing. So we were one member short from the original dispatch.
Understood. Lieutenant, when you arrived, given the fact that you did not know where you'd be searching, you got actually indicated previously that the flagpole, the fire hydrant, et cetera, that part of the lawn, that part of the yard was behind you as the cruisers pulled up and you parked your cruisers waiting for everybody to get there, correct?
When I arrived, I parked almost at the end of the driveway of that residence, sir.
Okay, was your tail facing the flagpole or was your nose facing the flagpole?
Tail was facing the flagpole.
So
sir.
you pulled up to the driveway, I'm guessing from Chapman?
Yes.
Heading north?
Correct, sir. Yes, from Chapman.
Okay, so you pulled over to the edge of the driveway, sort of on the wrong side of the street, I'm guessing.
Same side as 34 Fairview, sir.
Understood. So the area and the grid area that you ultimately decided to search and ultimately were directed to search, that was all behind you.
Yes, it was, sir.
And it was dark out, obviously.
Yes, it was, sir.
Getting dark.
It was dark. It was winter, so it was dark at
Okay.
5 o'clock.
Your focus was certainly not on the area behind you at that point, correct?
While
As
we
a
were
matter of fact, your
driving, sir?
focus wasn't really anywhere, was it? Because you
No.
didn't know where you were going to search.
Correct, sir.
Okay. Ultimately, your team members began to arrive one by one, and each one of them would stay in their car, or would they get out and come coordinate with you, like at your cruiser?
No, as they arrived on scene, they would come out because Lieutenant Tully had already arrived on scene. He was technically the third member of the state police on scene.
Okay.
So once he got on scene, I was already out talking to him, and I was marking off the area we were going to search.
Understood. He ultimately, at some point, did direct you to a location behind you, which you were not currently focused on, toward the flagpole, the fire hydrant, you said.
Yeah, I wasn't focused on any area at that time, sir, no.
You marked those the areas out that Lieutenant Tully directed you to with some sort of grid coordinates, or was it just sort of a mental grid?
No, I wound up marking, stepping it off in the area I wanted to search, sir.
Did you use any string or rope or anything like that to physically grid the area off?
No, I just marked a line in the snow, sir, where I wanted to
Understood.
start and where we wanted to end.
And you did that with footprints?
No, with the shovel, I made a mark where we wanted to start and end,
I
sir.
see. So sort of dragging a shovel in the line.
Oh,
in the
just
snow.
where the berm was, sir. I knocked the berm down, made an obvious impression of where the shovel was
Okay,
at the starting location where ideally I wanted to end.
perfect. You indicated that the area that you were searching was relatively undisturbed snow. You said that in direct examination, correct?
It was undisturbed, yes, sir.
But the street, everything from the berm in, the street had been plowed, correct?
To a point, yes, sir.
All right, and so that would be disturbed snow.
Yeah, to a point, yes, sir.
And what was the point?
To where the snow that got plowed in, it all rose up just like the end of your driveway would. There was a good 3 to 4 foot high barrier on each side of the street. Once you were able to knock down that initial barrier of snow, the level of snow dropped down to the normal depths that you would have seen in anyone's front lawn at that time, sir.
And is that what you're calling the undisturbed portion of the snow?
Correct, sir.
Okay. Lieutenant Tully told you that you were going to be looking for a man's shoe, a sneaker of some sort, or a shoe of some sort, correct?
He said sneaker, yes, sir.
And he told you that you'd be searching for plastic, red plastic potentially from a taillight. Is that right?
I said taillight pieces, yes, sir.
Did he indicate that some of them would be red, some might be clear, might be a combination of the two?
He didn't indicate a color either way, sir.
He did direct you to where he believed you should search. It was his direction that sort of gave you your grid coordinates, correct?
He indicated where the vehicle had been parked and where the victim's body had been located and suggested that was the primary area to search.
Did he tell you whether or not he knew from personal knowledge where where John O'Keefe's body had been?
He did not, sir, no.
Did he tell you whether he had personal knowledge where any taillight material might be?
He did not know, sir.
Did he tell you that he had any personal knowledge where an impact site might have been?
He did not know.
Did he tell you that he had personal knowledge that there had been an impact site at the location?
No, he just said he believed the incident involved the vehicle.
Okay. One of your goals when looking at the search location was to obviously remove the snow as methodically as you could, correct?
Yes, sir.
You wanted to not only remove layers of snow, but then ultimately expose the layer beneath it with as little disturbance as possible. Is that right?
Correct, sir.
I think you noted that the plow had not plowed all the way to the curb, so the snowbank was sort of in the street, not in the yard, or at least a few inches from the curb line and not in the yard, correct?
Correct, sir. As I stated, as some of the responding members parked, they were thinking they were parking in a safe spot in the street, and their cruisers wound up being stuck at the end of the night.
And you and your team had some experience doing searches in snowy conditions, being from Massachusetts, I'm guessing.
Missing person searches, we've never been out for an evidence search in this specific type of conditions, but we have done missing person searches.
So this was the first time you and your team had executed a search of this nature in these kinds of conditions for these kinds of items?
In blizzard conditions, yes, for an evidence search, yes.
But you did indicate on direct examination that although it was blizzard conditions and the winds were high, and we've learned that windy conditions sort of define a blizzard in some respects, the visibility was relatively good.
Yeah, with our headlamps, we had pretty decent visibility.
I want to ask you a couple of questions about the techniques for conducting a search like this in some sort of snowfall. Obviously, as a specialist in searches, one of the things that you put as the highest priority is documenting exactly where the search is conducted, what techniques are used to conduct the search, and what, if anything, is found and exactly where it's found, correct?
Yes, documentation of your search is important, yes, sir.
You'd also want to document the time that things are found, correct?
Yes, you want those documented.
And you'd want to document the relative locations between and among items that are found. How close are they to each other? How close are they or far are they from a stable landmark, a static landmark, correct?
So we will mark items, sir. Okay. Measuring in between distances, they do get stamped when we mark our items. Measuring them would be at the discretion of the investigators themselves.
And obviously that would be among the best practices to clearly document how a search is conducted, correct?
Correct, sir.
Another way to document the evidence or the search is to do it through either video evidence or photographic techniques, right? Just photographing, forensic photographs of where things are found, contextual photographs moving into close-up photographs, correct?
That would be at the discretion of the detective, sir.
And in this case, that discretion lay with Lieutenant Tully, correct?
Yeah, he was the incident commander, correct, sir.
You indicated a number of hand tools that you brought with you to the search to make sure that you had the tools necessary to get through the snow and get to the items that if there were any items out there, to get to the items you were looking for. Is that right?
Correct, sir.
And you did, in fact, remove layer by layer of snow and sort of sift through it as best you could, correct?
Yes, sir.
That also included some shovels where a shovel full of snow might be gathered and then turned over, correct?
Yes, sir.
All right. That was done somewhat methodically, is that right?
Yes, it was, sir.
And you wanted to make sure that you weren't missing anything as you were digging through the top layers of snow and getting down to something closer to the surface, correct?
Correct, sir.
And at that time, what was the level of snow, if you can estimate it? How much snowfall?
I believe the area, not living that far from that location myself, was anywhere from 15 to 18 up to maybe 20 inches in certain towns.
And again, this is after 5:45, 5:48 in the evening of January 29th.
When the first item was discovered, it was 5:45.
Okay.
Yes, sir.
Obviously, a search of this complexity and with this many individuals and with those conditions required some level of significant coordination by you and your team, correct?
Yes, sir.
You had to account for all the personnel who were there. Is that right?
Correct, sir.
That included, I'm going to go through a quick list: Bearden, Beausoleil, Carrier, Luis, O'Brien, O'Hara, you, and Biscardi. Is that right?
Yes, sir.
So there were 7 individuals as well, Lieutenant, as 7 vehicles to account for, to make sure you're not driving over the wrong areas, walking over the wrong areas, standing over the wrong areas, correct?
Correct, sir.
And not only did you have to account for those 7 officers, each of whom arrived in their own vehicles, you also had to make sure that those vehicles were positioned in the right spot to make sure you don't drive over the area that you need to search and might be impacted by your cars, correct?
Yes, sir. After Lieutenant Tully arrived on scene, the remaining cruisers never came past the initial location of where we believe the incident occurred.
Before he came on scene, the cruisers that were there were down toward the driveway, closer to where you were, and you, of course, were positioned with your back to the location that ultimately was searched, correct?
Yes, sir. That was 2 of the 7 cruisers, yes.
Okay. Once you learned where you wanted to search, you literally had to sort of turn around, physically turn things around to begin searching behind where you had originally positioned yourself. No fault of your own, you just didn't know where to go. You had to sort of turn around and go backward toward the area of the flagpole, away from the area of the driveway, correct?
Yes, sir.
And so as you began to focus on the other side of the house, the other side of the driveway, you had to actually reposition a couple of the cruisers. You didn't have to, but you chose to reposition a couple of the cruisers to turn their lights back around, correct?
Oh, that is correct, sir.
At some point, you've indicated that there were other individuals who you noticed were at the scene. Is that right?
Yes, there were non-cert members on scene, sir.
Okay. And those non-cert members included, or they numbered at least 5 individuals, not including Lieutenant Tully. Is that right?
I believe that includes Lieutenant Tully, sir. I believe it was 5 total.
Okay, so 5 does include Lieutenant Tully. There were 4 others that were non-cert members, correct?
Correct, sir.
And those were members, I think you've earlier testified that those were members of either Massachusetts State Police or Canton Police or both. Is that right?
I believe it was both, yes, sir.
And you did not recognize those individuals?
I recognized one of the state police members. I believe a second one was also a state police member that I'm not familiar with.
Okay.
And then 2 other members that I believe were Canton Police, but again, not familiar with them.
And these individuals were obviously, it's dark. You're not paying attention to them. You're not paying attention to what they're doing. They probably have hats and hoods and gloves on, I'm guessing.
Well, they didn't arrive on scene right away, so we were already well into our search before they even arrived on scene. The only one who was on scene originally was Lieutenant Tully.
If you weren't paying close attention to those, and 2 from Canton Police, correct?
Yeah, including Lieutenant Tully, it'd probably be 3 MSP and 2 Canton Police, sir.
Okay. Excluding Lieutenant Tully, who was working very closely with you, the other 4 individuals, they were in full uniform or they were plain clothes?
Plain clothes, sir.
And your focus, once you began your search, once you stood up the team, turned your cars around and realized exactly the grid where you were going to search, that's when what your focus was on, correct?
Yeah, I was focused on our search area, correct, sir.
And when you're searching a line, for instance, if it's a line that extends to your right or to your left, the search that you're conducting is literally right directly in front of you, correct?
Well, you're always looking left or right because you're staying online with your teammates, so you always have a full view of the scene you're searching, sir.
Understood. I'm not saying that you look down and never look up again, but I'm saying that your focus, the main focus of your search is directly in front of you. That's why you do a line search. So you can take small steps, search in front of you, move forward, search in front of you as a line, as almost an entity, single entity moving forward, correct?
That is best practice, yes, sir.
That's how you make sure you don't miss an overturned leaf that you need to overturn, that there might be a knife under or a gun under or something like that, or a bullet casing, something like that, correct?
Correct, sir.
Or a tail light, right?
Correct, sir.
All right, so as your focus is, your world sort of collapses a little bit. Your focus is in front of you. You're obviously working with your team members left and right. You're moving forward very, very gently, very methodically, very technically as you move forward and the whole line moves forward on that grid, correct?
Correct, sir.
So you're not necessarily paying attention to what's happening behind you, off in the distance, in the dark, to your left far, to your right far. That's not what your focus is on, at least at that moment, correct?
No, sir. Our focus is forward as we're moving forward into our search area.
Thank you. In addition to the 5 individuals, Lieutenant Tully included, and the other 4, There was also another person that made contact with you from 34 Fairview, correct?
Yes, when we first arrived on scene, someone had exited the residence onto the front steps, front porch area possibly of that mudroom.
I'm sorry, I didn't mean to interrupt you.
Of that mudroom, so that right door, the exit, the door closest to the garage, sir.
Can you describe that person for us?
It was an adult male wearing a hooded sweatshirt.
Did that person approach you or one of your team members?
No, he never left the front door area.
Did he say anything to you or one of the team members?
He asked if we were here for what happened earlier. We replied yes, and he turned and went back inside the residence.
And as you sit here, you don't know who that person is?
I do not, sir, no.
But he's a male, I'm guessing middle-aged?
It was not a child, sir. It was definitely an adult male, sir.
Adult male wearing a hooded sweatshirt?
Yes, sir.
Thank you. You testified that you recovered, having a hard time speaking, it's been a long day. I apologize. Let's try that again. You testified that you recovered a piece of plastic first before you recovered the shoe, or do I have that backwards?
No, there was one piece of taillight located before the shoe, sir.
Understood. You've also indicated that of the, I think you said 6 or 7 total pieces of plastic that were found, that all of those pieces of plastic and the shoe were found basically right next to each other, correct?
I don't know the exact distances, but they weren't too far apart, some several inches to others maybe a foot or two. I don't know the exact distances, sir.
Without assigning an exact measurement down to the millimeter, Lieutenant, you've earlier indicated that all of the pieces and the shoe relative to each other, it's just relative to each other, were found within a foot or so of each other, correct?
Eyeball, again, as the distance I just said, sir, from inches to maybe a couple of feet. I know they all are geomarked with exact coordinates that, could be measured out at a later time, which again would have been at the purview of the detectives, but we did not measure them. Again, all eyeball that night.
Understood. When I say, and it may have been a bad question on my part, Lieutenant, and if it was, I apologize. When I say a foot, within a foot of each other, I don't mean a foot apart. All of them you've earlier testified would be inside of a foot total, correct? Or maybe 2 feet now?
I don't think they'd be quite that close, sir. I think they were maybe in between each item, sir, or close to it.
I have just a moment, Your Honor. Okay. I know this isn't necessarily a memorization contest about your prior testimony, but do you remember testifying about this specific issue? Here I go again. I can't speak. This specific issue about a year ago, back in 2022 at a grand jury?
Yes, I did, sir.
Okay. Do you remember exactly how you described where everything was with relative, May 5th, is that a fact at the grand jury?
Okay.
Relative to each other, do you remember how you testified exactly?
I believe I said within a few inches or a foot away. Yes, sir.
Excellent. You've rattled off times and dates like I've never seen before. So it's exactly what you said. So within a few inches of each other, maybe a foot is what you said, correct?
That's what I said. Yes, sir.
Okay. So if it's maybe within a foot, this is an 11 and a half by.
Hold on, y'all. We got jury questions, y'all. Hold on.
Questions from you, to which I responded, go ahead and start. I don't have any additional instructions.
Okay, sorry. I'm just trying to get us all together. So this is for Christopher Scher. They had some jury questions. It sounds like they had jury questions, so just want to make sure that we're able to listen in on those. Where did the audio go?
the way that I did. And with that, is there anything further before I have them come in for and read that deadlock jury instruction for the people?
Oh shit, hold on.
It should not play any part in your deliberations.
Hold on.
Disclosed that we reached a verdict. Do we actually enter the courtroom like in minutes? And I responded, please do not concern yourself with this. It should not play any part in your deliberations. I did speak with both sides before providing that response, and it was agreeable to both the people and defense that I respond the way that I did. And with that, is there anything further before I have them come in for and read that deadlock jury instruction for the people and defense?
Your Honor, we understand the reasons for the courts
Deadlock.
the charge to the jury to keep on deliberating. We do object for the record, and we ask for this trial because we've already asked for this trial in the past.
Okay.
The court, because they've said that this deadlock should declare this trial. Thank you.
Okay, and I'm going to deny that at this point. This happens pretty frequently, at least from my standpoint, my experience. So I'm going to give them this instruction, allow them to continue to deliberate. Typically, if they come back after this, sometimes they're able to reach a verdict, sometimes not. So I'm going to give them this instruction, deny a motion for mistrial at this juncture. They've only been deliberating for, let's see, how many hours? Now I have to do math. So I believe they started at 1:45 yesterday. So, and it's 3:00. So they really haven't been deliberating that extended period of time. So given all of that, I do intend and will give them this instruction. I'll have them come in and deliver it.
Now this is interesting that they don't have a verdict.
All right, welcome back, and you may be seated. It's my understanding, jurors, that you have returned from deliberations indicating that you believe you cannot reach a verdict. I'm going to ask you to please return to the jury room and resume your deliberations in the hope that after further discussion, you will be able to reach a verdict. As you deliberate, please keep in mind the guidelines I gave you earlier. Remember, it is your duty to consult with your fellow jurors and try to reach agreement, if you can do so, without violating your own judgment. To return a verdict, you must all agree, and the verdict must represent the judgment of each of you. As you deliberate, you should carefully and seriously consider the views of your fellow jurors. Talk things over in a spirit of fairness and frankness. Naturally, there will be differences of opinion. You should each not only express your opinion, but also give the facts and the reasons on which you base it. By reasoning the matter out, jurors can often reach agreement. If you think it would be helpful, you may submit to my clerk a written list of the issues that are dividing or confusing you. It will then be submitted to me. I will attempt to clarify or amplify the instructions in order to assist you in your further deliberations. When you continue your deliberations, do not hesitate to rethink your own views and change your opinion if you decide it was wrong. However, none of you should give up your honest beliefs about the weight or effect of the evidence only because of what your fellow jurors think or only for the sake of reaching agreement. So at this time, I'm going to have my clerk come around and take you back to the jury room, and we'll see you soon, hopefully. It doesn't matter who. Somebody needs to-
We shall wait and see what happens, y'all. Somebody in there want to go not guilty for sure.
Lieutenant, there was one other thing that I wanted to ask you about, which is you had indicated to Lieutenant Tully at some point close to 6 p.m. or so, it would be helpful if you and your team had a photograph of what it was you were looking for, correct?
Yeah, I believe after we found the first piece or two, I asked him if he had a photograph that we could look at just to see how large of an area,
So that
how large
would-
of a piece we were looking for, sir. Yes.
Fine. So that would just timing wise, if you found the first piece at 5:45, first piece or two, maybe 2 or 3 or 4 minutes later after that, maybe 5 minutes later. So let's place it at 5:50, close to 6. Something like that?
Yeah, probably between 5:45 and 5:50 possibly, sir.
And you said to him at the time, it'd be helpful if we had a photograph of what it is we're looking for, correct?
Yeah, I said that would help. Yes, sir.
And Lieutenant told you that the vehicle did not have a photograph because it was still en route from Dayton being transported to Canada, right?
He did say he did not have a photograph and it was being towed back.
Okay. Thank you, Lieutenant.
Thank you, sir.
Okay, Mr. Brennan.
Thank you.
Sir, you mentioned that there were about 5 people not on your CERT team at some point arriving at Fairview Road or the area of it.
Yes, that's correct, sir.
3 of them were Mass State Police. You mentioned Tully and 2 of his colleagues.
Correct, sir.
Did you see anybody taking photographs of the items that you found?
Yes, Lieutenant Tully was taking photographs while we were there, sir.
And did you see somebody putting the items in bags?
Yes, they did, sir.
Was that one of the 2 people that were with Lieutenant Tully?
Yes, correct, sir.
And you mentioned there were 2 Canton police officers. Were they part of the search?
They were not, sir, no.
Were they on the grid?
They were not, sir.
Did you ever see them in the area on the grid?
I did not, no, sir.
They were there. Were they involved in any way in the crowd?
They weren't the only people that ever came on scene other than us, and those local officers were at some point, the media did arrive on scene.
When you say on scene, is on scene different than on the grid?
Correct, just in the general vicinity, sir.
Did you know what the Canton police officers were doing?
I do not know, sir.
Did you ever see either of them ever come on your grid?
They did not know, sir.
Did you ever see anybody place or toss or throw anything onto your grid?
I'll allow it.
Did you ever see anybody place or toss or throw anything onto your grid?
I did not know, sir.
Did you ever see anybody intrude on the grid and leave an item?
Choose a different word.
Did you ever see anybody physically intrude upon your grid?
No, no one did that, sir.
You were asked about best practices memorializing. The person who was taking photographs.
Hold on for a second.
Slow down a little, Mr. Brennan.
You mentioned best practices of memorializing items. And you also mentioned Lieutenant Tully was taking photographs.
Yes, that's correct, sir.
Do you know if those photographs were time and date stamped?
I believe they were, sir.
Is time and date stamping with photographs best practices in memorializing things?
Yes, they are, sir.
Now, before you defined the grid and before you began that search, you knew other state police officers, didn't you?
Yes, I did.
Did you know a person by the name of Trooper Yuri Buchanan?
Yes, I do know him, sir.
Did you know somebody at the time known as Trooper Michael Proctor?
Yes, I do know him, sir.
Were either Michael Proctor or Trooper Yuri Buchanan at Fairview that night?
No, they were not, sir.
Did you see them at any time from the point you got there at 4:56 p.m. until when you left?
No, I did not see them there, sir.
You mentioned that somebody came out of a side door at 34 Fairview who had a hoodie on.
Yes, that's correct, sir.
How long were they outside for?
Maybe 10 seconds, sir.
Did they at any time interfere with your search?
No, they did not.
Did they at any time try to discourage or dissuade you from searching?
Objection, Your Honor.
Next question, I'll sustain that.
Did that person do anything to impede your search?
No, he did not.
You were asked about your conversation with Trooper Tully,
Yes, sir.
and he mentioned, or you characterized, he was very satisfied that what you had found, everything you were going to locate at that time.
That's correct, sir.
Did he ever suggest that he expected that you would not find anything else?
No, he did not.
Did he ever suggest that there was no other trace evidence there?
No, he did not.
Was there a discussion that he or you or other people may come back to search further at a different time?
We offered to come back at a later date, and he just accepted our offer, but we were never contacted to come back, sir.
When you offered to come back, was that based on your assessment that it was a difficult area to search?
Correct. Again, as we talked about probability of detection, we'll base that on 10 different categories, give him a baseline percentage chance of it. Would we have found what we were looking for? I told him there was a good chance we did not locate all the evidence, asked him if he wanted us to come back at a later date, sir.
And when you mentioned that you couldn't finish the search because of the grass, tell us a little bit about what made it difficult because of the grass.
Even using the push brooms, we couldn't properly move the snow off the grass as we were moving it. And with the dark, even the headlamps, I didn't feel like we were clearing it enough to continue searching it. I think our best efforts would be to focus on the street, because I was more concerned about eventually the plow coming in, clearing curb to curb and moving any evidence that was on the street. My thought was, if with the grass not being able to properly clear it, at least that would be contained to be searched at a later date as the snow melted.
And given those assessments, is that some of those reasons why you offered to come back?
Yes, sir.
I've shown you some photographs you've identified about some of the pieces that you found or the pieces that you found that night. I'd like to show those photographs to the jury.
Okay.
If we could show Exhibit 73, please. Is that one of the photographs you identified earlier?
Yes, it is, sir.
Is there a chance, Ms. Gilman, that we could do a close-up of that? Can you describe what you're seeing?
It's a piece of clear taillight. It's got rigid edges, some indentations on it, distinctive markings.
Did all of the pieces you found have those type of markings on it?
Not sure if they had those exact same markings, sir. I'd have to compare the photos.
Was there different colors of pieces that you found that night?
Yes, we also found pieces of red taillight as well.
Could we see 73A, please? Without blowing it up, if you could go back. Is 73A a picture from further away of the same piece?
Yes, that's what it appears to be, sir.
Was it easier to see these pieces that night in person than it is in photos, or was there any difference in the ability to identify these pieces?
Objection, Your Honor.
Sustained.
When you saw the piece from where you were standing, did it look any different than it does in this photo?
No, it doesn't, sir.
Can we see 75, please? In that picture from this perspective, can you see any pieces of taillight?
There's a piece of red taillight in the left-hand side of that photo, sir.
On a little bit of a mound?
Correct, sir.
Is that where that piece was found, on the mound?
No, that's the photo, like we discussed earlier, sir, that came up with one of the shovels. And you can see, when you get close to that photo, you'll see the actual molding of the overturned shovel.
So it was scooped up and then placed on that mound?
Correct. As the trooper overturned it to start beginning to sift through the different layers of snow, that's where he deposited that snow, sir.
Could we get a close-up of the left side of that picture, please? Can you see the shovel marks near that piece?
Yes, they're directly behind it and off to the left. You can see the molding of the shovel.
You can see a bit of a divot to the left of the red.
Yes, correct, sir.
Is that part of imprint from the shovel?
Yes, it is, sir.
Could we see 75A, please? Is that a closer picture of the same item?
Yes.
The imprint, does that give you a clearer view of the shovel you were speaking about?
Yes, it does, sir.
Could we see 76, please? Is that one of the photographs you identified earlier?
Yes, it is, sir.
And that piece, was it found at ground level,
Yes, that photo is where that item was located, sir.
touching the ground?
Yes, sir.
Could we get a close-up of that, please? And if we could have 76A, please. Is that a picture of the same item?
Yes, it is. Just zoomed in, sir.
You can close that, please, and turn the lights on. Thank you. To be clear on the timeline, your first colleague arrived at what time?
4:54 p.m., sir.
And you arrived at?
4:56.
You mentioned that it looked like fresh snow.
Yes, sir. The area we searched was fresh, undisturbed snow.
And when you got there at 4:56, when you described fresh, undisturbed snow, is that your impression when you first got there at 4:56?
Yes, I had realized that the plow had not cleared curb to curb.
You began your actual search at what time?
Right around 5:20, we wound up again. We moved a couple of our cruisers around just to add extra headlights, extra lighting on the scene itself.
And the first piece of evidence was found at what time?
5:45, sir.
Your area that you searched, did you say it was 8 to 10 feet?
No, sir. The area I marked off was just over approximately 60 feet. We'd gone about 8 to 10 feet towards the end of the search without locating any more items, and that's where when we suspended the search.
How much of your focus was near the street area?
Only 99% of it, sir. As soon as we got to the grass and realized we couldn't clear it properly, my main focus was on that street, just again, because I was concerned about the plow coming through at a later time.
You were worried that if you didn't finish the street, there could be some impact from plowing?
Yes, sir.
And did you say 99% was the street area?
Yeah, approximately, sir.
Thank you very much.
Anything, Mr. Jackson?
Yes, briefly.
Okay.
So the search went approximately 60 feet.
That's the area I marked off, sir.
And in that 60 feet, you started close to or adjacent to the front door, correct?
Correct, sir.
And in that 60 feet, you were doing the type of search that we described earlier, you described earlier, about going just a few paces at a time and starting to move material out of the way to try to get down to the surface, correct?
Yes, sir. All working together. Yes, sir.
And you did not find 40 pieces of taillight at or near or on that street or the lawn or any place else, correct?
Yeah, I don't know the overall number, sir, but
And neither did your colleagues.
correct, sir. We've never been notified how much has been located.
The only thing that you found was concentrated in one area, maybe a foot or 2 feet in diameter. You said 6 or 7 pieces, and a shoe, correct?
That's what we located, yes, sir.
You didn't find a black baseball cap, correct?
We did not, no, sir.
And in the photographs that we've seen, clearly not undisturbed snow, correct?
The photographs are us moving, after having moved the snow, sir.
Some of it is y'all moving the snow. Some of it is disturbed snow on the street or at the curb, correct?
After we had moved it, yes, sir.
You indicated that Trooper Proctor and Trooper Buchnick, you know both of them, correct?
I know who they are, yes, sir.
Or know who they are. When Trooper Tully told you that the vehicle was en route and could not provide you a photograph at, let's call it 5:50 p.m., did he tell you that the vehicle had actually been secured at Canton PD about 1.5 miles away at 5:35 p.m.?
No, he did not say that, sir.
Did you know through any other means that that vehicle was just 1.5 miles away at 5:35 p.m. before you ever found the first piece of taillight? Did you know that?
I did not know what time it arrived, sir.
Thank you.
Do you know what time Trooper Tully told you he did not have a photograph?
It was sometime after we found the first piece, sir, so sometime after 5:45, sir.
Thank you.
All right.
That's all I have.
All right, Lieutenant, you are all set, sir.
Thank you.
Here we approach.
Okay. One up, please.
All right, y'all. I'm waiting on the feed to start for the rest of the bond hearing for Millie. So I don't see it. I don't see it up here yet, but
All right, so jurors, every day I've been asking counsel whether we are on track. Usually, I haven't reported it to you as much, but I can tell you now that we are definitely on track, maybe a little ahead of schedule, which may just mean down the road a little bit, we'll be back on track. But because we're on track a little ahead of schedule right now, we're done for today.
Ah!
So we'll let you
Leave it to
stay
Bev.
with those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be very careful with your social media use. We'll see you tomorrow.
All rise for the court, please. Close your notebooks and follow me.
Goodbye.
all right. So no more Karen Reed for the day, which is great. Okay, fantastic. But I'm trying to find the rest of the bond hearing for our folks. And okay, wait a minute. Is this this from earlier? All right, I may just have to off y'all for a while. Okay. All right, I'm still looking for Millie, y'all. So just give me a minute here. I'm not seeing them live at the moment, y'all. So I'm gonna give it another few minutes, and if not, I'm gonna go ahead and end my stream. But then I'll come back later with details. And so, and if anybody's curious, I'm looking on NBC Miami. That is where I am searching for the feed. That's who I was watching earlier. That's who we were watching earlier. Excuse me. No, she said waiting all day for the ruling on this bond. Just laugh. I don't know. I don't know if I don't know if Bev is telling the truth or not. I don't know what's going on with Bev, but she said. But what? Okay. Are y'all gonna give us another little uppy datey? How to stream? Let's see. Stream. What's on the stream? Click the stream. Okay, child. Right now they showing the weather. I don't really need the weather right now, honey. We need that. We need that Melly update. We might be. Let me. Y'all know what I'm gonna do. I'm gonna go out there and see if there is anything on the docket. So before anybody get in here asking what's going on, I'm searching for the Millie feed, y'all. Just in case anybody's curious on what's happening. I'm looking for the feed, y'all. And I'm also about to check and see if anything was filed. Court clerks. Search. Okay, so nothing new has been filed. So that's, because after the judge gives their ruling, it usually is filed. So nothing has been filed. So that's a good sign, and we haven't missed. Oh Lord, my heart just dropped. I just, my heart just dropped tremendously. Um, Okay. Let's switch. Yeah, I'm just like shaken by that. Okay. Yeah, I'm not seeing no feed. Let's see what the people. I mean, people would think about this Melly trial too, y'all, is that people are low key crazy about this trial, like they are crazy about Karen Reed. And I'm not like, I haven't really been getting a lot of comments except for these last two videos that I made. Like people are really going hard in the comments. And it's like, y'all, I don't know who needs to hear this, but I am not extremely invested. I'm not extremely invested into this trial. I'm just reporting on it. I'm just telling y'all what come out of it, and I'm following the shenanigans. I have no emotional attachment to this trial. At the end of the day, two young men lost their lives, and this young man is on trial for it. Everybody deserves good legal representation. Everybody deserves due process. That's all I can tell you. It's not on y'all, so I might not be able to stream it with y'all. I might have to circle back around. Oh Lord, these people are just not. Stop it. Oh God. Like I'm literally leaving out of here at 3:00. Like I don't care what type of call, I don't care what they got going on in this call, but at 3:00 I'm out of here. Y'all, I'm just waiting on the feed, y'all. I don't know what to tell you. I'm just out here waiting for it's been 5 hours. And it's not up yet. So I don't know. All right, y'all. So there's not a feed up here right now. All right, 1 second, y'all. Yeah, Ashanti, we watched the last trial. So I get it. People are like so invested that they're like mean and crazy. And it's like, you don't have to be like that. You don't have to be like that. We just gotta figure it out. We gotta figure out what. All right, we're hopeful today. He's been through a lot. Yada yada yada. Um, 1 second. All right, y'all. I'm not gonna hold y'all on here for too long. The thread isn't there. I will try and give an update whenever one is made available. And I just hope y'all have a good day. Reminder, we are still on verdict watch for Tyre Nichols as well as Christopher Scher. So I will be on call, on hold for those as well. And I just hope everybody has a good rest of the day. See y'all later.